Lordship, mentioning for recusal of the case in which the petitioner had prior professional acquaintance with the Lordship.
We mentioned for
With,
release.
with Milord's kind leave, Milord, this matter, Milord, I've mentioned on several occasions, Milord. This is a 2022 matter. Your Lordship was pleased to admit the matter last year, Milord, on March 2025. I was kindly praying for, Milord, for listing of this matter, inclusion in the list. Paper books have been filed, Milord.
We are not including now.
Lordship, I have a permitted to mention for withdrawal, Your Lordship.
We mentioned it will appear as to be mentioned.
Your Lordship, I'm mentioning related to FMA 1337 of 2025. Here the date of the judgment is not correct.
For correction?
For correction.
Yes, please handle.
Yes,
Yes, sir. You for the respondent?
My Lord, Mr. Indrajit Dasgupta is appearing for Union of India, my Lord. He will be here, my Lord. Let my senior friend start.
Thank you. Fair enough. You take your seat, we will just hear him and you take your note.
To see, just have made a gist of everything.
Thank you, thank you.
It will appear. May I read, Milord?
Yes, you can tell us also. I mean, need not read the entire thing. You know the facts. You can indicate what is the challenge against.
Well, I am challenging a decision of the Enemy Property Authority Home Secretary. What happened, my lord? This is a case under Enemy Property Act. I am challenging the order passed by the Joint Secretary of the Ministry Home.
Yes.
There was a first round litigation. My case is that I am, by virtue of third transfer of interest, I have become a owner. Original owner was Sayyid Fateh Ali Mirza.
Right.
He bequeathed by Heba in favor of his wife and two daughters. One of the daughter in turn sold it to one of the transferee, and from that I have purchased it. I went for the purpose of his recording. I found that it has been recorded under enemy property. Therefore, my lord, I made an application on the section 18. Then section 18 was not considered. I moved the High Court in writ jurisdiction. Then Honorable Justice directed they did not file an affidavit. Without affidavit, matter was decided. Court hold that since no affidavit is filed, I say that whatever said is correct, but refer the matter for its adjudication to the authority holding that since all the transferees are Indian citizens, that cannot be denied. However, if they have got any unimpeachable document, they can deal with the matter. Then, my lord, I had been to the Home Secretaries for 2 or 3 occasions. It was hard, not decided. Ultimately, contempt was moved, and following contempt, matter was decided. They decided it against me. Basic reason for decision is that according to the first HEBA was in 1952. According to they called for a report from the estate manager. Estate manager reported that they got a publication from the foreign Pakistani national, a book. A book says that person died in 1948. Therefore,
book by a Pakistani author.
Yes, a Pakistani author, and Pakistani book published saying one page that he died in 1948. Therefore, according to them, if one person died in 1948, the question of transfer does not arise. That is the sum of the matter.
The only basis of holding that person.
Yes, that I will be showing, my lord. Then, my lord, I came up this honorable court again challenging that. It was moved in writ jurisdiction because I was under the impression that initiation was writ, therefore it will be heard by writ court. But referring to section affidavit was exchanged, referring to section 18C of the Enemy Property Act, the single bench holds that it has to be an appeal. It was.
What is wrong in that?
No, I'm not saying. I'm not saying. Then it was converted to appeal.
What it was?
It has been converted to appeal. Paper books, paper. Now it is before lordship.
So appeal lies before us. This
yes,
court.
Yes, yes.
We'll just once look into the act because we are not very.
Only 1 second, my lord.
Yes.
First, lordship kindly turn to paper book. There are 2 paper books. There are 2 paper books.
Paper books, yes.
Paper books, if your lordship take the trouble to see my list of, I suppose, my lord, it will help you, my lord.
Yes.
Referred decision was taken pursuant to order dated, that is in annexure P, page 71, P8. It is relevant. Page 71. Page 60, operative part.
60 or 71?
60 starts the order of the High Court.
This
And 71, Miller, 71 is operative part, Lordship kindly.
this order directed it to be
Yes,
heard.
in such view of the matter, regardless of limitation, the representation of the petition must be considered and disposed of in accordance with law, keeping in mind that the case that the petitioner and the transferee are all citizens of India and not enemy, which has not been controverted and cannot be disputed in the eye of law. In view of the fact that no affidavit in opposition was filed, however, if the respondents have records which are unimpeachable, which show otherwise, the respondent shall be entitled to take decision in accordance with law, even if it against the interest of the petitioner. The entire exercise must be completed within such and such time. Therefore, beloved, what I wanted to submit before you, there is a finding of the court that all are citizens, it is undisputed.
But Mr. Rai, this is not final because it once it's really
Yes, yes. On that score, my lord,
prima facie, yes.
prima facie, yes, court holds that if otherwise any unimpeachable documents is like, therefore, my lord,
Yes.
what was my case? Just it is admitted position, Lordship kindly sees. Petitioner's case in short. Original owner.
Which page?
Just I'm giving it from my own, my lord. It is admitted
So
position.
your case you have said already.
Already case. Just in a same.
Not Mr. If they controvert, then we'll look into it. But you have said that there are 3 heaven numbers. You are the third one. 2 heaven.
I'm the third. First, my lord, Lordship, just for a while.
Very well. Yes.
Sayyid Fateh Ali Mirza was the original recorded owner. Original owner by registered Hibanama dated 10/12/1952 gifted the land to the, this particular date will be relevant, my lord. Then 3/8/1970, one of the donee, namely Kazmi Bibi, transferred the property in favor of Mehboob Ali. Mehboob Ali transferred the land to the petitioner and annexure P4. Then it is recorded, all these things are there. Then I showed, my lord, direction, exception, what is there.
So they did not act on it, contempt. Then after that, they
Yes,
decided.
yes.
Should we look into the impugned
Yeah,
order?
that's impugned order, my lord. Yes.
Impugned order means the
Impugned order is, my lord, at annexure P13, page 167 to 182.
this is the last final impugned order.
Final impugned, which is impugned before.
in appeal. Yes. Right.
May I read, my lord?
Yes, please.
Yes. Disposal of representation dated 8/11/2012 preferred under section 18 of the NMB Property Act. I am skipping over. Whereas the applicants herein, namely C. Asfakul and others, have made the present representation dated 8/11/18 being agreed by the order of the custodian of.
We think you can skip over the first paragraph also.
First
Because this
paragraph,
is the quotation of the section and all.
Whereas the applicants through their representation dated have made the following prayer to set aside and recall the decision order of vesting of such land as NEB property under the NEB property. That was my initial prayer.
Yes.
To divest the land and pass appropriate order in this regard, issue necessary instruction order to appropriate authorities for correction of record of right, deleting the recording of NEB property in respect of the referred land from the record of right. Whereas during pendency of the said representation, the applicants have filed a writ petition before the Honorable High Court of Calcutta, being number has been disposed of by the Honorable Court by the order dated directing the central government to consider the representation within 2 months. Whereas The provisions contained in Section 18 of the 1960 as well as the Transfer of Property Vested Enemy Act, opportunity of hearing was offered to the applicant. The office of the CPI Kolkata had filed written statement on author refuting the applicant's claim being devoid of enemy. Then, my lord, what is there? What I submit, my lord, though affidavits have been called for, facts remain. On the basis of pleadings of all the parties, it was decided. They filed their statement, I have filed their objection, taking into consideration all these things. Even then, court, then, my lord, by virtue of gazette notification being number dated, all district magistrates and district collectors have been designated as ex officio deputy custodian of enemy property for preservation of the properties failing within their territorial jurisdiction. Hence, the district magistrate Murshidabad, it is their, the custodians, they are recording the statement of custodian. It is not their statement, my lord.
The original, vendor, the owner, he was an Indian also.
He was an Indian, his name was recorded. Then, my lord, hence the district magistrate Murshidabad has empowered to issue direction for preservation and maintenance of the property in dispute in exercise of the power conferred to the custodian of enemy property for India under Section 8 of the Enemy Property Act 1968. With the approval of the Government of India, custodian of enemy property for India, and issued guideline on how to preserve and manage the immovable properties vested in custodian by standing order number such and such and standing order number ato, which were circulated to the state district level officers all over India, and these orders cover almost every aspect of enemy properties work entrusted on them. Since the enemy properties are to be preserved and managed by the district authorities on behalf of the custodian of enemy property of India, they have authorized to take such measures as they consider necessary or expedient for preserving the interest of the custodian of enemy property for India. Prior to issuance of the standing orders by virtue of Defense of India Act 1962, followed by the Enemy Property Act 1968, as amended time to time, the district authorities, district magistrate, district land reform officer, JLR, etc., are empowered to maintain, preserve, and manage the enemy property situated under their jurisdiction with the approval of CPIO. The immovable property located in district Murshidabad under various maujas, as mentioned herein, originally belonged to and recorded in the land revenue record, RS record of rights, at the material point of time, that is on 10/9/1965, in the name of Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, who had left India and migrated to Pakistan and became the first president of India. Hence, the immovable property owned and migrant automatically vested in the custodian of enemy property for India under notification number such and such. The details of enemy properties, details of the enemy property situated in Mauja, Hussain Nagar, Golabak, and all these Miller, owned by Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, declared as enemy property as under. Then details of the land they have given. I'm skipping over. See, Sayyid Fateh Ali Mirza, the alleged executor of the Hevanama, dated 10/12/1950, who died in 1948, which was much prior to the date of execution of the alleged Hevanama. The date of death was duly certified by C. Jayanto Mondol, their submission. Jayanto Mondol, WBC's executive estate manager, State Judicial Department, Government of West Bengal, statutory body. Based on such information, it is clear that the Sayyid Fateh Ali Mirza was not alive during execution of the said alleged Hivanama. The submissions of the applicant's counsel that through the local inquiry they have learned that probably Fateh Ali Mirza expired in the year 1959 or 1960 is nothing but a concocted and fabricated statement without any legal basis or authenticity. Hence, the genuineness of the Hivanama itself is questionable, and the same is nothing but a false fabricated document and void ab initio and having no legal implication. Not only the genealogy and the relationship as mentioned in the alleged Hivanama was totally wrong as compared to the genealogy provided by the statutory body, that is the state manager of Murshidabad, State Judicial Department, Government of West Bengal. The subject property in the CS era belonged to Sayyid Fateh Ali Mirza. That is my original. After his demise, the property was devolved upon his ancestor. Being successor in interest, Worship kindly keeps this their submission. It is not just.
Yes, we have seen that.
Being successor in interest in subject property along with other properties in the name of Sayyid Fateh Ali Mirza were devolved upon Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, as inheritance. The name of Sayyid Iskandar Ali Mirza, Sayyid Fateh Ali Mirza was recorded in the arrest record of rights. Subsequently, after his migration to Pakistan, all properties owned by Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, were vested under custodian and enemy property for India by various notifications 1965 issued in exercise of powers conferred under Sub-Rule 1 and Rule 130 of the Defense of India rules, that as per provisions of the Section 20 of the Enemy Property Act as amended by Enemy Property Amendment and Validation Act 1927, shows that subsection A provides that the provisions of that as amended by the Enemy Property Amendment Validation Act 1970 shall have and shall always be deemed to have effect for all purposes, as if the provisions of this act amended by this act had been in force all material times, which shows that the Enemy Property Amendment and the Validation Act 1927 is giving retrospective effect to the provisions of EP Act. Further, bare reading of the provisions of 20 Enemy Property Act as amended as Enemy Property Amendment Act shows that the subsection C provides that no suit or other proceedings shall, without prejudice to the generality of the foregoing provision, be maintained or contained any court. Miller, should I skip over because this is not
Yes, please.
is not narrable.
No.
Then, Milord, this is the recorded submission what the enemy property wing submitted. They have recorded it. Then I was allowed to give an exception. My answer to you was that page A regarding LS. This is my answer. What I have there. To substantive regarding LS death of Sayyid Fateh Ali Mirza in 1948 and execution of registered Hibanam in 1952 as raised in written statement. To substantiate the death of Sayyid Fateh Ali Mirza in 1948, the concerned authority has relied upon the referred book, which has published from America and alleged author is a foreign national. To substantiate the death of Sayyid Fateh Ali Mirza in 1948, certain pages of the said book have been referred to and relied upon, but the referred pages did not mention the date and month of the death of Sayyid Fateh Ali Mirza. Therefore, on the face of record, the alleged year of death without including the date and month of the death is vague, indefinite, baseless in accepting the actual death of a person. Such statement cannot be accepted to substitute the death of the said person in 1914 as alleged. Apart from the same publication statement in the referred book on the date of 1940 is not supported by any document, far less of legally acceptable documents in this regard. The referred book is unauthentic. No reliance can be made on such publication in such book, and being personal in nature, mere statement publication in such a book about the death of a person is not legally acceptable. Such book is not acceptable as public documents within the meaning of Section 74 of the Evidence Act. In the written statement to prove the death of Sayyid Fateh Ali Mirza in 1940, the report dated 18/5/2023 of the estate manager had been relied upon. In this respect, it is stated that the report of the estate manager is based on the same referred book. No other authentic and legally acceptable document in this regard has been referred to and furnished. Therefore, such statement report is not acceptable. Furthermore, the estate manager is not legally authorized and competent to certify the death of any person. In the context above, it is relevant to mention herein that deed of Hebanama dated 10/12/1952 is a registered document. For the purpose of registration of a document conveys the executant of the document has to attend before the concerned register in the registration office, and in his presence the executant.
We are disturbing you for a minute. As we've gone through the judgment, we find 2 or 3 points. We are telling you, please correct us if you have any additional point. First, estate manager's report. Estate manager is not an authority under any of the acts to certify death. First, his report was based on a foreign author's book, which is not a substantive evidence of death. 2. Thirdly, we find that the burden of proof has apparently been shifted on you to show that he died when he died. Because there are certain findings which say that no counter document has been produced by you to show when he died. Now, the question is whether if they don't produce in the first instance, it's their contention that he died before the deed.
Yes.
Otherwise, there's a presumption of correctness to the registered deed.
Yes.
So if they allege that, they are to prove by cogent evidence first.
Yes.
If they don't prove, then burden, the onus does not shift on you. So burden of proof was reversed, one. Secondly, the basis of that report and authority of estate manager are doubtful. And thirdly, also there is a finding that after Fateh's death, his successors came into the picture, and then he left for Pakistan, and thereafter in 1965 it was vested. So therefore, these are your main points, because first
Yes.
of all, registered document. Very first point is estate manager had no authority. Secondly, his basis was a foreign author's book, which is also not a basis. Thirdly, we find that the burden of proof has been reversed. You have been cast with the burden to show that when he died, but it's their case; they should have proved. And registered document presumption is there.
Yes.
So these are the points involved.
Another thing, my lord.
Yes.
First is the basic. What is the law about? Whose property can be vested?
Yes.
I am summing up my.
Yes, yes, happen.
My submission, my lord, will be.
Yes.
Lordship kindly take the trouble to see the list of dates or whatever. I will just on the
Their contention is not even that they nowhere do we find in their defense that it was a enemy. If the gift deed was executed prior to his death, then there could not have been it could not have been an enemy property at all.
Yes.
Very well. Let us also see what you are citing.
Basic argument. Number one, property belonging to Indian citizens or transfer made by and between Indian citizens. Land cannot be included as enemy property within the meaning of the Act. Regarding the fact of the alleged date, Sayyid Fateh Ali Mirza, no reliance can be made on the publication in such a book having no evidentiary value. More so, such publication of book is not corroborated by any death certificate of the appropriate authority, and no reference was made regarding the date and month of death. Report of estate manager in this regard is not acceptable without jurisdiction. Third point below, all the transfers of land were made by registered instrument. Registration of a document carries presumptive value of valid document, and the authority failed to discharge its onus in proving a duly registered document as void or invalid in dialogue. Third and last one, according to them, if a property they intends to vest, there has to be order of vesting.
There was the vesting
No.
order.
I will be showing no order of vesting of land. Property of Indian citizen cannot be treated as vested as enemy property. Notification of vesting does not cover the referred land within its schedule. And last but one, the impugned order passed without any consideration of the order of the Honorable Court passed in these are my submissions, my lord. So far as the last part, because my lord will find from the order impugned, penultimate paragraph, what is the finding?
Yes, you have seen that. Yes.
Finding is conclusively on the basis of 1948 death, therefore, no other finding. Whatever might have been discussed, finding is, penultimate finding is on the one line, 1948 death.
Other aspects are apparently not considered.
Other one. Therefore, my lord,
I will like to see two things. One is this notification, because the notification you say does not cover this plot.
Yes.
And secondly, we'll also see the report of the estate manager.
Yes. Lordship kindly, notification. Page 56. Page 56, paper book 1. This is a reply to my information. I asked him through a RTI application how it has been vested. Then I came. My question is, my lord, my lordship kindly take, sure there might be not fully legible, but I am reading it, my lord. Whether the land, my question was that whether the land referred to in the land schedule below have been declared vested in the custodian of enemy property for India, if vested, the date of order decision if any vesting. Yes, date of vesting is 10/9/1965.
No, this is something else. This is the reply. We are wanting
reply.
The estate manager filed a report.
Or report. Then page 57. This is the notification. My lord,
notification, yes. Notification is.
According to them, it has been vested to the as enemy on 10/9/1965. I have showed, my lord, page 56.
Yes.
Then page 57. Government of India, Ministry of Commerce, notification in exercise of power conferred by subsection 1 on Defense of India rule, central government hereby orders that all immovable property in India belonging to all in held by and managed on behalf of all Pakistani nationals shall based in the custodian of any property for which immediate effect.
But when the Hibanaba was made, he was not a
Yes.
Pakistani national. He later on went to Pakistan.
According to them,
Even if you take their case.
even if they claim subsequently, my lord, then my lord, this is the schedule, page 59. The schedule, all lockers, safe deposit, page 59, body, any person, all these things.
These are consequential.
Consequential. Therefore, by a general notification, it is supposed in 1965, entire property of a Pakistani national has been vested under any waiver. My question would be before that one question, whether any fact finding is necessary, or they will suppose a person is a Pakistani national and it will be vested. How do I know the person is a Pakistani national?
Under the Act, no prior hearing is required.
Under the Act, my lord says, my lord, rules are there. But I am what it, there has to be a reason. How do they know that this property belonging to a Pakistani national? Then, my lord, lordship turn to estate manager's report. Admittedly, in 1965, general notification is made. All properties, lordship, I stress on the line, belonging to Pakistani nationals. Therefore, my lord, I will support by judgment, my lord, said, my lord, how do the authority know these properties belonging to a Pakistani national? It cannot be come from there. There has to be a fact finding. There has to be a fact finding to the effect this person. Then I will come to the section says, how the section says. Here also says belonging to. The question of belonging to when comes, it has to be, must be a reason order that it is a Pakistani national. We found it.
Yes.
Then my lordship turned to estate manager's report. They relied upon.
Yes.
And schedule I have referred to, schedule doesn't contain the specific land. Schedule said lockers, all things.
Schedule does not contain any land.
Any land.
All lands of properties of Pakistani national.
All.
It's a follow-up of that.
Follow. Below estate manager report.
But it refers to detailed in the schedule annexed here too. Though this is
no, that it does not.
There is no other. Very.
Report of estate manager at page 154 of the paper book, my lord.
Yes.
There. Yes, my lord. Report in respect of Sayyid Fateh Ali Mirza, file number such and in response to file number such and dated 1/3/2023 of the Office of the Custodian of Mini Property of India, Ministry of Home Affairs, Kolkata, duly sent by the district magistrate. I have searched relevant documents. After considering the available office record, this is noted that Sayyid Fateh Ali Mirza of Nawab Bahadur family related to last Nawab Bahadur, Waris Ali Mirza, and Sayyid. Well, two names are my lord will find. So, first name is Sayyid Fateh Ali Mirza, and next name is Sayyid Fateh Ali Mirza. Next one is related to mine. As mentioned in that, needless to mention here, Sayyid Fateh Ali Mirza was. We can skip over first Fateh Ali Mirza. We are not concerned.
They say that. On the other hand, you are.
Yes. On the other hand, Sayyid Fateh Ali Mirza, whose son is Iskandar Ali Mirza. This person, they are saying that Pakistani national is not related to Nawab Bahadur family. Sayyid Fateh Ali.
Sir, we have seen the only source referred to is this book.
And next page, my lord lordship turn it to
Yes.
what is the genealogy and where from they have got it.
From that book itself.
Next page, one line. Sayyid Fateh Ali Mirza died 1940. In a bracketed portion, it is there.
Yes.
And this is the book. They have given 1 pages. And this is the genealogy.
In the book also, this is the probably the relevant place where it has
Oh
been
yes,
in that box.
in the box it is 1948. This is the source. This is their corroborative document to say that a person has died in 1948. On that score, Milord, I have been found that this is proper. Now the question is another thing, Milord. They are admitting that this particular skin test measure, according to them, is I don't know, because we have purchased in 30 years back. Where from we'll get? A question was asked to me. I say it is subsequently as gathered. They could gather the information from the district level. They failed to do it. But especially they are holding on the basis of book published from America, from a foreign national who says he died in not a date, not a month, year. Even they could not find any death certificate otherwise. And on that score, Milord, they have hold that this property belongs to Pakistani national, therefore it should be vested. Then I am running after them. And we are the last transferee. Even if they cannot succeed. Absolute succession cannot devolve upon the person. If he has other sons and daughters, that should be divided. Nobody cares that all of them went to Pakistan. Now, my lordship, kindly turn.
Let us hear the other side. What means?
Then, if
Yes, Mr.
I have
we reply
judgments
if-
also, I have that subsequently.
Yes, yes, Mr. Dasgupta.
The main question is, my lord, the citizenship of the present owner is not being challenged, my lord. The vesting was done in the when in the RS record a person's name was found, and this was not a person who nobody knew. He was the first prime minister of Pakistan.
Who?
Sayyid Fateh Ali Mirza. That is why it is not
No,
as
no, Fateh Ali Mirza.
Sikandar is Iskandar Ali Mirza.
Iskandar is his son.
No, Iskandar
Son of Fateh Ali.
Son.
RS record.
What is interested in Prime Minister's father?
My lord, and the book has been written by his son, not by a foreign author, so-called foreign author.
Okay.
This book, he is writing about his father. That is why so much reliance is being placed on it. Namal, kindly take up my...
No, somebody else wrote. Humayun something. Humayun Mirza.
Why?
Yes.
Namal, kindly take up paragraph, page 188, my opposition.
It's come to page 154. 154.
154
Report.
See the source, page 154. By Humayun Mirza, only he is the grandson of Fateh Ali. So he might, for all that we know, he might not.
Fateh Ali's son is Iskandar, possibly.
His son wrote it.
Yes.
So for all that we know,
Iskandar's son wrote it.
for all that we know, he might not have seen his grandfather also. He has given a genealogical table on the basis of, even if it was written by an acclaimed author.
Right.
Can this be a proof of death? And on that ground, you have turned down.
Well, there are other.
His name was recorded in the records of rights. His successor's name was recorded. Subsequently, he left for Pakistan. Successor left for Pakistan.
Fateh Ali.
Fateh Ali never left.
Our cases are, we found Iskandar Ali Mirza's name recorded there. That is our case.
Your case is found at page 171. Please come to page 171, Mr. Dasgupta. Please come to page 171.
My lord.
171, Roman 4. That is
the subject property CS0 belonged to Sayyid Fateh Ali Mirza. After his demise, his property devolved upon his ancestors and typing.
This is the way you have proceeded. turned it on its head.
Being successor in interest, the subject property along with devolved on Sayyid Iskandar Ali.
Yes. Name of
Sayyid
Syed
Fateh
Iskandar
was
was
rec-
recorded.
Sayyid
Son's
Fateh
name was also recorded
Name of
Yes,
Sayyid, the
records.
son of, was recorded.
in the artist record. So
Yes,
he was an Indian national till then.
Yes,
Up to
because
son.
this came in 1960s.
So his father executed the Thibanama prior to that. Prior to his death.
But then in RS Malad, his possibly name will not come.
R.S. Iskandar's name has come.
Iskandar names will not come if it has been distributed by Hibanama. The owners of the
Artist records is no proof of title, Mr.
definitely not. Definitely not.
There is a registered deed
But
of gift.
when Malad, when the when a property is identified
If
as
there is a registered Hibanama, Mr. Dasgupta,
Right.
and the records of rights, what do you rely on for title? You tell us. Whatever you say, we'll accept.
but then I
And
will
record
also,
that it is your submission.
I will also make this submission, my lord. Even the register.
Whatever property you're getting, you're grabbing.
No, my lord. These challenges coming up now. Property was, my lord, it came under the Enemy Property Act in 1967.
Maybe.
Subsequent transfer, nobody has bothered to get their name corrected, my lord. Not a single person.
As we say, record of right do not confer or take away title.
My lord, even deeds do not.
Basically,
Deeds-
whenever they came to know, they challenged.
Well, there are recent judgment where deed is also not sacrosanct regarding title, man.
No,
It
deed
is a
may not be
presumption.
that depends on the facts of the
Yes,
case.
ma'am.
Here you
So-
have proved nothing. You have not even challenged the deed.
Well, our
Your only source of information is a book written by apparently the grandson of the original owner,
Right.
who says that in a book box, in a genealogical table annexed to his book, he has given a year of death.
Right.
On the premise of that, you brush aside a registered deed, despite admitting that this person was in India, an Indian citizen, name was recorded in CS, son's name was found in RS records. So
Right.
up to son, they were Indians. So therefore, the date of the
Fateh Ali, we are never saying that he was an enemy. We are saying Iskandar left.
so Fateh Ali executed the Hibanama. If he was not an enemy, then how can it be?
Then we are saying, my lord, that he could not have.
Your only ground is 1948
Right.
death.
And my lord,
No proof of that.
and will kindly see the recording in the RS. Iskandars could not have name could not have had it died. It must have
After
been
death of
recorded
the-
after.
After death, Iskandar's name was recorded.
But Hivanamas, their name should have been there, my lord. If the Hivanama was
That
absolutely
is the basis
genuine.
of your countering the Hibanama. There's a registered Hibanama. The registered owners do not get their name recorded in the records of right. Title does not go by that. Settle, Mr. Dasgupta. Does not only create, extinguish. You know the language by heart.
Right.
Does not create, confer, extinguish any title.
Right.
It is record of right entries.
Yes. Whatever, other than that, my lord, we have found, my lord, it was, my lord, they have never disclosed the fact. We had filed a supplementary in the writ petition. They were tenants on the same property, my lord,
Maybe.
for so long. They could not, my lord. My lord, why
You are hit by Mohinder Singh Gill. That's not there in the order. Anywhere. What you are now saying. Squarely hit by Mohinder Singh Gill. The ghost of Mohinder Singh Gill. That haunts
then
you.
it will go back to the office.
No, it will not go back. You have never disclosed anything. For the first time, you are disclosing something here. Why should you relegate it? You just set aside this order. And the vesting.
The best thing, my lord, was
These people are toiling for quite some time.
well, that is his whole argument. Even
Your
with the
whole
past.
argument is that book by his
But they have
grandson.
been toiling till from 17, but before that they could not get their name registered anywhere. Before they could not challenge anything.
Whenever they came to know of this recording by the information slip, they challenged.
2017.
So what?
They have purchased it possibly 30 years ago. They are saying, well,
Yes, their title was never disputed. Whenever they must have shown a cause of action.
no,
Must have shown something.
they have not. They are
Prompted you to ask for that information, Mr. Rai?
Yes,
They are paying
after getting information, it is recorded in the single bench. After getting information
Why
that
did you seek for that information? What was the trigger?
what I can
What
follow.
was the trigger for your asking for that information? Your title was challenged. Otherwise, you are hit by this limitation also.
I wanted to get our name recorded. Revenue officer said that it cannot be recorded. It is lying vested. Then I came. That is the recording.
my lord,
That is the fact
This is
finding in everything.
there is a presumption of some foul play. my lord.
Is it the case that why I
Some
came
foul
late? They come to a
They
decision.
were tenants there.
We are sure of foul play.
Well, they are tenants there. No, my lord, kindly see, state operates in another manner. They have seen a person recorded. They, in fact, I will say it is rather in a mechanical manner. They have proceeded on the, it is
And
not as if they have.
There is no
proceeded as
malice,
SPD.
malice on the part of any
It
official
is
of the
not,
state.
the,
We are not saying that.
Well,
Why should there be any malice against a party?
they have found a name in the record of rights.
You take away a person's property like this, Mr.
My lord, again, my lord, it is not an intention to take away somebody's property.
No, not your intention to take away somebody's property. Any property act vesting, what is it?
For a citizen of Pakistan who have left, that was the whole intention. So we found a person.
All premises are bad of your order. First, the person who executed the deed of gift, registered deed of gift, was never a national of Pakistan. According to your case also, you have never said that he was a national of Pakistan.
No, we have.
His son went to Pakistan subsequently. So we are not concerned about his son because the father executed the deed of gift. So first premise goes, not a foreign citizen at all. Your only premise is that he was not alive when the deed of gift was executed. Apart from that, there is no other scope of challenging the Hibanama. You have also not challenged that Hibanama. It's a registered document.
Well,
Notice is presumed under Transfer of Property Act on registration.
well,
Notice definition. And you are the union.
well, Malad, the state is also a party. These,
So you have not challenged.
these
You have
things
not
are
challenged the registered deed of gift.
No.
They have not got their names recorded. Which one is more serious? Which has more presumptive value? The records of rights or the title deed? Tell us. Registered deed. You tell us record of right has it. We'll record your submission and dismiss their appeal. Saying that we are obliged to Mr. Dasgupta for this argument. There's nothing. This is not a case where you fight tooth and nail. না তন্ময় যখন গেছো নিয়ে নাও just take your seats. Yes, you want to add something, some other code,
ও যাবে কোথায়?
some other code, go to that code.
the rate, same. No. The same argument I mean that they have admitted by taking paying rent, they have admitted the ownership of the custodian of enemy property.
That
This
is not a
one
court,
remains my-
that is not a impugned order within.
We'll record this.
The controversy.
And
you have
not only
witnessed
that, my lord, they did not disclose it throughout the proceeding. It was only upon since old records were been we found it after.
We find it anywhere in the order, Mr. Dasgupta?
No,
It's
order-
nowhere there. There were 2 rounds of litigation. 3 rounds, in
But
fact.
it is now on record, my lord. Subsequent in appeal, my lord, subsequent facts can be, if evidence can be. This was a writ petition, my lord. It was a writ petition.
Understood. You have brought it in what manner? In the writ petition, you have filed a supplementary.
Yes, ma'am.
We'll say that. We'll say that. Just take your seats, all of you. If actually, if you go wrong, just point out.
Yes, sir.
The present appeal is a converted writ petition. First up, the brief facts are that according to the appellants, one Syed Fateh, FATEH, Ali Mirza, the original recorded owner of the subject plot, executed a registered Hibanama on December 10, 1952 in favor of his wife and 2 daughters. First up, next para. On August 3, 1973, as per the appellant's case, one of the donees, namely Kajmi Bibi, transferred the property in favor of one Mehboob Ali, who, in turn, transferred the property on December 30, 1998 to the present appellants. Full stop. Next para. The appellants contend that when they attempted to have their names recorded in the records of rights, it came to the knowledge that the property had been recorded as an enemy property, coming under the purview of the Enemy Property Act, 1968. First up, accordingly, information in that regard was sought by the appellants under the Right to Information Act, upon which it was given out that the subject lands had been vested under the 1968 Act by a notification dated September 10, 1965 and September 11, 1965. Push up next para. Accordingly, the appellants preferred submitted a representation before the appropriate authority under the 1968 Act, pointing out that the original owner and all the subsequent transferees were Indian citizens at all points of time, and as such, the property does not come within the purview of the 1968 Act. Push up initially, such application was such representation was when you came to Justice Pratik Prakash Banerjee, that representation was dismissed or inaction.
No, inaction, inaction.
Such representation was not being acted upon, prompting the present appellants to prefer a writ petition before this court. Push up. The writ court, while directing the respondent authorities to dispose of such representation, made certain remarks on the basis of the doctrine of non-traverse, since no affidavit in opposition was used by the respondents to the said writ petition of the appellants, to the effect that the that there was no dispute to the fact that the property was not an enemy property. Full sub next para. Subsequently, despite the direction of the writ court, the representation was not being disposed of, for which the appellants were constrained to file a second writ petition, file a contempt application. Full stop. During pendency of the contempt application, the the competent authority passed an order.
My lord, if I may, because these are very critical facts.
Yes, yes.
During writ petition, some other authority has been there. Even the direction was not on the statutory authority. During the contempt, we made it clear that contempt does not lie, because whether the authority is not even a party. Then in the contempt petition, the direction of the power that the statutory authority will dispose of.
Who was initially directed?
Well,
Some other authority.
But the secretary, Muller, was directed. Secretary was directed. Then Muller.
Next, but in the contempt proceeding, it was pointed out by the respondents that the initial direction was passed by the secretary, who was not the competent authority under the 1968 Act, upon which direction was given on the appropriate authority to dispose of the representation, upon which the same was disposed of ultimately by an order dated August 25, 2023. Full stop. Next para. Being aggrieved by the same, the appellants preferred another writ petition. Full stop. During pendency of the writ petition, it transpired that an appeal lay against such order under section 18 capital C of the 1968 Act to this court, upon which the writ petition was converted to an appeal. Full stop. The said appeal is now before us. Full stop. Next para. Learned counsel appearing for the appellants submits that the entire premise of the order, sustaining the vesting under the 1968 Act, was apparently a report submitted by the estate manager, which, in turn, relied on a book published by a foreign author. Full stop. Next para. Merely on the premise of the year of death of the original owner, Fateh Ali Mirza, being mentioned to be 1948, the authorities proceeded on the premise that the gift deed could not have been executed in the year 1952 by the original owner, which ultimately culminated in the transfer in favor of the appellants. Full stop. On such premise, the representation of the appellants was disposed of. Full stop. It is argued that In the absence of any death certificate by any competent authority, comma, neither the estate manager had the authority under law to certify the demise of a person, comma, nor could the book by a foreign author simpliciter be sufficient basis for coming to the conclusion that the original owner died in a particular year. Full stop. Next para. Secondly, comma, it is argued that the the transfer deeds all along the line, comma, including the original transfer deed executed by Fateh Ali Mirza, dated December 10, 1952, were registered documents, and presumption of correctness is attached to such a registered document, comma, unless rebutted. Push up in the present case, comma, there was no rebuttal whatsoever worth the name on the part of the respondents. Full stop. Therefore, comma, the impugned order was vitiated by contravention of law. Full stop. Next para. Moreover, comma, it is argued by the appellants that Fateh Ali Mirza was never a foreign national, comma, let alone the citizen of an enemy country, enemy nation. Full stop. All the transferors of the title deeds, which ultimately culminated in the transfer in favor of the appellants, comma, it is argued, comma, have been Indian citizens, and as such, comma, the rigors of the 1968 Act do not apply at all. Full stop. Next para. Lastly, comma, it is submitted that the notification dated September 10, 1965, comma, which was purportedly the premise of the vesting of the subject property, was bald in nature and couched in a blanket fashion, comma, without mentioning the specific property of the appellants in its schedule. First up, it is submitted that the tenets of natural justice demand that a hearing and an inquiry should precede the vesting of a property in the garb of enemy property. Pushed up. Next para. Learned counsel appearing for the Union of India controverts the submissions of the appellants and argues that the author of the book, on the basis of which it was held that the original owner Fateh Ali Mirza expired in the year 1948, was none other than the own grandson of the said Fateh Ali Mirza. Full stop. Next para. As such, comma, an element of authenticity is attached to the said statement in such book. Full stop. Next para. It is pointed out that it is nobody's case that Fateh Ali Mirza was a foreign national. Full stop. Even as per the case of the respondents before the authority, comma, the said Fateh Ali Mirza that after the demise of the said Fateh Ali Mirza, comma, his properties devolved upon Sayyid Iskandar, Iskander, Ali Mirza by inheritance. Full stop. The name of Sayyid Iskandar Ali Mirza was recorded in the arrest records of rights. Full stop. Subsequently, comma, after his migration to Pakistan, comma, all the properties owned by Sayyid Iskandar Ali Mirza, comma, including the subject property in the present litigation, comma, were vested in the custodian of enemy property by dint of the notification bearing number 12/2/64 hyphen capital E full stop capital P small ty pty একটা কথা dated September 10, 1965, comma, issued in exercise of the powers conferred under sub-rule 1 bracket of rule 133 hyphen Roman V capital of the Defense of India rules 1962. Full stop. Next para. It is thus submitted that since the appellants kept mum over the matter throughout during the prolonged period prior to filing of the writ petition, comma, they cannot be permitted now to dispute the vesting of the property under the 1968 Act. Full stop. It is also submitted that the appellants never had their name recorded as owners in respect of the subject property. Full stop. On the contrary, comma, learned counsel for the respondent relies on a supplementary affidavit filed by the respondents in the writ petition, which was converted to the present appeal, where it was pointed out that the appellants have been paying rents, comma, in the capacity of tenants, comma, in respect of the subject property. Full stop. Thus, comma, obviously, comma, the appellants conceded to the custodian of enemy property being in charge of the property. Full stop. Thus, comma, it is argued that a contrary stand of ownership cannot now be asserted by the appellants on the strength of a purported transfer deed. Full stop. Next para. This is all, Mr. Dasgupta. This is
Only one thing, matlab, they have also never produced the original deed. Matlab, and, had it been a civil proceeding,
transfer deed.
transfer original
Have you pointed that out in your supplementary?
Which transfer deed I did not produce?
original transfer deed?
Every document was
No,
a
no.
part of record, every document annexed. What did he say?
Original
Where did they
transfer
not produce?
from-
That is
Original
not the
from?
case of anybody.
matlab,
It is undisputed. What he said.
On what basis you were saying, Mr. Dasgupta?
matlab,
It is not even your case anywhere that they did not
no,
produce it.
possibly, matlab, the original, because in affidavit in
No,
opposition.
no, but
I
on the
did not
contrary, it was considered that registered deed is sufficient proof.
Hebanama, matlab, the Hebanama.
Yeah, everything was produced.
So what is this?
Hebanama original they have not produced.
Yes,
How do
it's
you
a
get
part
that?
of record.
Where do you get that?
It is a part of
Where do
record.
you get that?
Matlab, I
It
found
was never
it
produced?
somewhere in my affidavit, the affidavit in opposition. matlab.
দেখাও। What from his
Learned counsel insinuates further that the original Hebanama was never produced by the
He
appellant.
gets me lord.
Sir, please take a seat. Next para. Upon hearing learned counsel for the parties, comma, we come to the following conclusions. Full stop. Next para. At the outset, comma, it may be noted that the argument as to the appellants admitting themselves to be tenants by depositing rent was never made, comma, nor did it form a part of the ratio of the impugned judgment passed by the Joint Secretary to the Government of India, which has been impugned before us. Full stop. Next para. Thus, comma, the respondents cannot be permitted to take such objection at the stage of a challenge to the original order dated August 25, 2023, comma, being hit by the proposition laid down in Mohinder Singh Gill. Citation to Mohinder Singh Gill. Full stop. Next para. Secondly, comma, we do not find anywhere in the impugned order dated August 25, 2023, that it was the case of the respondents that the original Hibanama was never produced. Full stop. Rather, comma, the Joint Secretary, comma, while passing the impugned order, comma, took into consideration the arguments of the parties that as to whether a registered deed carries a presumption of correctness. Full stop. Thus, comma, we cannot entertain such contention of the respondents at this stage as well. Full stop. Next para. On the merits of the case, comma, the sole premise of the respondents for turning down the representation of the appellants was that the original owner Fateh Ali Mirza, comma, whose ownership of the property has never been disputed, comma, executed the Hibanama dated December 10, 1952, comma, on which the appellants rely as their first chain deed of title, comma, met his demise prior to the execution of the deed, that is in the year 1948. Full stop. Such so-called information again, comma, is derived from a report filed by the estate manager
One 54.
comma Murshidabad. Full stop. From the said report, comma, which is a part of the records, comma, the only source of reference for the estate manager to come to the conclusion that Sayyid Fateh Ali Mirza died in the year 1948 was page number 344 of a book by the name of double inverted মধ্যে caps দিয়ে from Plassey, PLASSEY বলা ছিল Plassey to Pakistan, comma double inverted শেষ করে comma ISBN 969-0-01621-0, comma American edition, first published in 1999 by University Press of America, comma written by one Humayun Mirza, comma allegedly the only surviving son of Iskandar Ali Mirza, comma the latter being the son of the said Syed Fateh Ali Mirza. Push up next para. Irrespective of whether the author of such book was the grandson of Fateh Ali Mirza or not, comma, a year of death mentioned in a genealogical table in a book published by an author, comma, which book is not an authority from any point of view on the question of such date, comma, could not be a valid basis of the Joint Secretary to come to the conclusion that Syed Fateh Ali Mirza died in the year 1948. Full stop. In the present case, comma, neither any death certificate was produced, comma, nor did the neither any death certificate by any competent issued by any competent authority was produced, comma, nor did the estate manager have the authority in law to certify the date of death of the said Syed Fateh Ali Mirza. Full stop. Even from the report, comma, it is found out that only the year of death, year of alleged death of Syed Fateh Ali Mirza is mentioned as 1948, comma, without any particular date or any other details regarding such date whatsoever. Full stop. Next para. Thus, comma, such so-called information on the basis of a book by a foreign author could not have been a valid or legal basis for coming to the conclusive finding that Fateh Ali Mirza met his demise in the year 1948, comma, thereby negating a registered deed of gift dated December 10, 1952, comma, executed by the said Fateh Ali Mirza prior to his Fateh Ali Mirza. Full stop. Next para. Secondly, comma, as rightly argued by learned counsel for the appellants, comma, a registered deed carries a presumption of correctness, comma, unless rebutted by cogent evidence. Full stop. In the present case, comma, no rebuttal evidence worth the name whatsoever has been produced to dislodge the presumption of correctness of such registered document. Full stop. Next para. Moreover, comma, from the impugned order itself, comma, it is found that the respondent's categorical case was never that Syed Fateh Ali Mirza was ever a foreign national, comma, let alone the citizen of a enemy nation, of an enemy nation. Full stop. Rather, comma, it was the categorical case of the respondents that the subject property, comma, in the CS era belonged to Syed Fateh Ali Mirza, and after his demise, the property, as per the respondents, devolved upon his successor, bracket is son, bracket close, Sayyid Iskandar Ali Mirza, whose name was also recorded in the RS records of rights. Full stop, thus, comma, the Indian nationality of Sayyid Fateh Ali Mirza and his ownership of the subject property during his lifetime has remains uncontroverted even by the respondents. Full stop. Next para. It is trite law that unless a property is owned by an enemy national or is an enemy property within the contemplation enemy national না, owned by an enemy double inverted মধ্যে or double inverted মধ্যে enemy subject double inverted clause or our double inverted enemy firm within the contemplation of section 2 within bracket small b of the 1968 act or is otherwise an enemy property double inverted মধ্যে under section 2 within bracket small c of the 1968 act comma the rigors of the 1968 act cannot apply at all. Full stop. Next para. Hence, comma, since there was no valid or legal basis for disputing the deed of gift executed by Fateh Ali Mirza, comma, which was the original source of title of the predecessors in interest of the appellants, comma, there cannot be any doubt that the vesting of the subject property, comma, which had already been transferred by Fateh Ali Mirza prior to his demise, comma, could not come under the ambit of the 1968 Act. Full stop. Next para. The Joint Secretary apparently turned the burden of proof on its head by observing that no document was produced by the appellants during hearing to show when Sayyid Fateh Ali Mirza died. Full stop. A negative fact cannot be proved. Full stop. More importantly, comma, negative fact cannot be proved. কেটে দাও. Since it was the positive assertion of the respondent authorities that Fateh Ali Mirza had met his demise prior to the execution of the deed of gift in 1952, comma, the burden and the initial onus was on the respondents to validly prove the date of death of the said original owner. Full stop. Next para. Once a registered deed of gift and subsequent chain deeds are produced by the appellants, comma, the burden, the onus shifts on the respondents, comma, who disputed such deeds, comma, to prove the date of death of the vendor beyond doubt. Full stop. Having not done so, comma, it does not lie in the mouth of the respondents to say that no challenge was preferred no attempt of mutation of the property was made by the appellants in their name at any point of time. Full stop. Although the respondents argue that the appellants never challenged the vesting under the 1968 Act at all material times, comma, in the same breath, comma, a registered deed, the notice of a registered deed is supposed to be the date of such registration within the contemplation of the definitions within the contemplation of the Transfer Property Act. Full stop. Next para. The respondents never challenged the registered deed of gift executed by Syed Fateh Ali Mirza on December 10, 1952, or the subsequent transfer deed by one of his donees, Kajmi Bibi, on August 3, 1973, and thereafter the transferee from Kajmi Bibi, comma, namely Mehboob Ali, having transferred the subject plots on December 30, 1998 to the present appellants, comma, all by registered deeds. Full stop. Next para. Thus, comma, we do not find any valid basis of the impugned order. Full stop. Next para. The notification of 1965, comma, relied on by the respondents only covered enemy properties and not properties which were owned at all points of time by Indian nationals. Full stop. Next para. In such view of the matter, comma, we do not find any substance or legal basis in the impugned order dated August 25, 2023, full stop. Next para, accordingly, FMAT 278 of 2025 is allowed on contest, comma, thereby setting aside the impugned order dated August 25, 2023, passed under Section 18 of the Enemy Property Act 1968 by the Joint Secretary to the Government of India, comma, Ministry of Home Affairs, bracket A, FFR Division, bracket close, full stop. Next para, we further declare that the vesting of the subject plot under the 1968 Act, comma, being bad in law, comma, is also set aside. Full stop. Any action taken pursuant to such vesting, comma, if still subsisting, comma, are hereby set aside as well, revoked and set aside as well.
My lord, kindly,
What has to cost? One second. Can 1 of 2026 also is also disposed of accordingly? Yes. No less.
kindly limit it to the part that so far as the petitioner is concerned.
Yes, you are absolutely
Because the other we will take
Yes.
the point of limitation my
right.
lord, from day one.
True, true, true.
My lord.
যেটা বললাম ওই
Because now others will come up.
vesting is also set aside
So far as the petitioner is concerned.
only insofar as the present appellants are concerned. Great. You are right, Mr. Kaswan. Thank you. এই তন্ময় মহিলা সিঙ্গেল এক্সাইটেশন টু নিবার 971 এসসিসি 40 এটা next
My lord, in this matter, I am appearing virtually. I am appearing on behalf of there are two appeals. The first appeal,
Lordship, I am appearing on behalf of appellant Nobu
I
Kumar
have
Das
the respect of 1 to 10.
not
use the
appearing.
microphone. Mrs. Chattopadhyay cannot hear.
Mr. Nobu Kumar Das leading the case, but he is not appearing on behalf of state right now. So let we engage someone as a junior,
Why
senior.
did you mention it in the list? It was already in the list before you
Yes,
mentioned.
yes, to item number 2 and 3.
Are you enjoying any interim order?
No.
No
No,
interim order. Let
I
it
am
go
the
down.
state.
Goes out of the list. You're for the state.
Yes, Lordship.
The
State
respondent.
appeals. State has
It's
preferred.
your appeal.
Yes, Lordship.
So let it go out of the list then.
but then in that case, I shall be prejudiced, my lord, if the matter
Why?
is go out of the list. Because
Why?
I am the successful writ petitioner. And
They're
the
not
challenge-
enjoying any interim order, Mr. Chattopadhyay. That we asked you.
That's true. My lord, that due to the pendency of this
No,
appeal,
we'll make that clear. Make that clear. An
Lordship,
adjournment is sought on behalf of the appellants. Full stop. Next para. Next para, na, sought for by the appellants for engaging a new set of counsel. Full stop. Next para. Accordingly, let the matter go out of the list. Full stop. It is made clear that mere pendency of the appeal shall not operate as a stay of the order impugned there.
I'm grateful to you.
এটা এই অ্যাপিলটা কি আজকে প্রথম এসেছে? অ্যাপিয়ার করছে তো? সেদিন শুয়েছিল। None appears for the parties at the time of call. Taking order.
My lord, I am appearing, my lord, item number 4. My lord, I am, is my-
Mr.
I
Sengupta.
am the appellant, my lord.
Yes, what is the matter, Mr. Sengupta? Move the appeal.
My lord.
Yes, move the appeal.
My lord, actually, I got an interim order, my lord, from the Honorable Division Bench. And my lord, appeal is to be heard, my lord, only thing, my lord, may I beg one indulgence? My lord, kindly fix next week, my lord, on Thursday, my lord, so that I can, I could not prepare myself. That
Why,
is the
Mr.
thing, my lord,
Sengupta, you're now fit.
No, I am now fit. Monday is the last medical checkup. So, my lord, kindly for next Thursday so that I can make my submission, my lord, and complete the hearing.
But
Because, my lord,
Mr.
I will cite some judgment because my
Mr.
junior
Sengupta,
has
we
to
have
be
been
there.
consistently putting matters out of the list by vacating the interim orders if
No,
appellants
my lord,
ask.
my lord, kindly.
This is the
My lord,
third
I
or
am
fourth item.
ready to, my lord.
No, then you move the matter. We are not
My lord,
granting answer. No, no adjournment. You should have been prepared. This is the fourth matter in the list.
my
And
lord,
today is hearing date.
only one day.
No, Mr. Sengupta. We have to be
All right, my
consistent.
lord, I'm.
Yes.
All right, my lord.
Do the matter, Mr. Sengupta.
My lord, I am for the respondent number 127, my lord, led by Mr. Amit Kumar Pan, my lord.
Yes, Mr. Sengupta. What is the matter?
Yes, my lord. Just a minute, my lord.
Previously also it was adjourned on your prayer. On
Yes,
20th
my lord, because,
February.
my lord, at that time, I had undergone surgery, my lord.
Yes, obviously, Mr. Sengupta, we understand that. But now
Yes.
it's long over.
Yes, but, my lord, because after all, my lord is here. That's why, my lord, I am ready to, my lord. That's why, my lord, so that I can prepare myself properly. My lord. All right, my lord. Kindly come to, my lord, the original, my lord. There's a paper book, my lord. Kindly come to.
We
Paper.
yes, my lord, Mr. Pan could not appear in the court, my lord.
Why?
He is fever, suffering from fever, my lord.
What fever? Mr. Pan has been coming to court.
Yes, sir. Today
Has
he is
not come.
coming.
You are saved by Mr. Pan.
Yeah, my lord. This is the
Both.
fate, my lord. This is God bless.
This is the
I think.
fun of Pan.
This
Both
is a
sides.
blessing.
Both sides.
This is a blessing from
Both sides can
my lord.
push up next pair as a last chance to the parties to argue the matter. The same is
Next Thursday, my lord.
made clear that if on the next occasion
Yes.
either the parties ask for adjournment or remain absent,
Yes,
appropriate orders will be passed in the absence of such party.
Obliged, my lord. Obliged. My lord, may I leave, my lord?
Yes. Next.
Item number 5.
Interim order. Order schedule. None appears for the parties at the time of call.
Appearing for the petitioners. I'm being led by Mr. Shaikh Ranjan Ganguly.
Move it.
Yes. I'm appearing for the petitioner.
I appear for the respondent.
Yes, Mr.
Look, this was the matter, my lord.
Just taken upon the last occasion. Just remind us of the matter, please.
This was with regard to the interest component in respect of Section 80 of the Act 2013. Lordship, the possession was taken by the Metro Railways and thereafter
23rd. Fair compensation. Right to fair compensation. Section
80 of the
80.
Act 13, Lordship, Right to Fair Compensation Act.
Right.
If your Lordship kindly sees Section 80.
Yes.
May I read it, Lordship?
Please.
When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited. Provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable. Lordship, now the petitioner is the landowner which was acquisition by the Metro Railways, Lordship.
Yes.
And in respect of such acquisition, Lordship, award was made and Section 80, this interest component was not given. So we filed a writ petition before the honorable single bench and an order was passed. If your Lordship kindly comes to the impugned order at page 165 of the volume 2. It starts from page 165. Your Lordship will get the order from. Lordship, I'm led by Mr. Lordship, I'm led by Mr. Siddhartha.
खुल लेता हूँ।
The order starts from page 167, Lordship, at volume 2. And the operative portion is at page 174 and 175, Lordship.
But the learned judge granted 9% till 1 year and then 15%.
Lordship, there is a miscalculation in the order, Lordship. If your Lordship kindly comes to paragraph 11. If I may
Yes,
be
we are there, para 11.
If I may be allowed, Lordship, I am led by Mr. Banerjee.
We allow both of you, you can both argue together. Please take your seat.
Yes.
We'll call up. After Mr. Banerjee finishes, we'll call up.
My lord was looking at page 165, the impugned.
75.
75.
We have crossed that stage.
Yes. Milord, what was allowed, Milord, was for a restrictive period. Milord, Section 80 of the 2013 Act, Milord, provides for payment of interest.
9% for 1 year, thereafter 15.
Yes.
Yes.
Milord, here,
That was here granted, but what is the mistake in the order?
Yes. My lord will kindly take note of 2-3 dates. Milord, the possession here, Milord, was taken on 21st of February 2017. And Milord, the ultimate Milord awarded amount, Milord, was paid to us, Milord, on 11th of June 2019. Milord, this awarded amount, Milord,
it should be up to 20th of February 2018, 9%.
Milord, this 9% is to be calculated on the
rate of
enhanced award. Milord, this 9% is to be calculated, Milord, on the enhanced award, and also, Milord, the area of Milord, the enhancement, Milord, which was granted later. I tell your lordship, Milord, 10 rupee, Milord, just Milord, for Milord, giving an analogy, Milord, initially 10 rupee was Milord awarded. Later on, Milord, this was enhanced, Milord, twice, 15 and 20. Milord, this 20 rupees, Milord, the balance 10 rupees was paid, Milord, at a later point of time. So, Milord, I was entitled to interest, Milord, on this 20 rupees, not, Milord, on the 10 rupees. Firstly, and, Milord, this interest on 20 rupees, I was entitled, Milord, from the date of, Milord, possession. Milord, here, Milord, what has been granted is, Milord, the interest on, Milord, the lesser amount and for, Milord, a lesser period.
Possession of the land was taken is rightly noted, page 175.
Milord,
please come to page 175.
Yes, Milord, I am at 175.
It is crystal clear that the possession was taken, compensation was
21st
paid.
February 2017, compensation was paid to the petitioner only on 30th August 2018.
Why
Milord,
two
this is Milord 2 dates because Milord initially Milord an amount was awarded, which was later on Milord modified. And ultimately, Milord, the balance awarded.
So whatever was
ultimate amount. Milord, I was
no, but Mr. Banerjee, since they had paid you some amount on 30th of August 2018.
Yes.
So for that amount, there should not be any further interest.
Milord, I am entitled to interest from the date.
No, we are calculating it on the basis of the entire amount, suppose.
Correct.
But if some part is paid,
Milord, that would be adjusted.
Yes, that has to be adjusted.
That would be
Date of
adjusted.
deposit will be calculated for that amount. It will be up to 30th August.
Milord, we have made Milord a comprehensive calculation in one page.
No, let us see the judgment first. Justice goes to judgment.
Therefore, it is crystal clear that though possession of the land was taken on 21st February 2017, compensation was paid to the petitioner only on 30th August 2018 and 11 June 2019. The petitioner is therefore entitled to interest on the amount awarded in terms of Section 80 of the Act of 2013 at the rate of 9% per annum from 21st February 2017 to 20th February 2018,
right,
and 15% per annum from 21st February 2018 to 30th August 2018. Milord, here, Milord, there is one mistake because, Milord, I was entitled to interest till, Milord, June 2019. Then, insofar as 2018, insofar as award amounting to rupees such and such is concerned, and from 21st February 2018 till 11 June 2019, insofar as the further awarded amount, Milord, of 2 crore 80 lakh is concerned. Here, Milord, the mistake occurred. Milord, I was entitled to 12 crore plus 2 crore. So, my lord, interest was to be calculated on, my lord, the total, my lord, awarded amount, my lord, till 11 June 2019. My lord, interest was calculated till 21st February 2018 on, my lord, my lord, pre-modified awarded amount. Where, my lord, the mistake occurred.
Give us your calculations.
Yes, my lord.
Give a copy to your friend.
Yes, my lord. Yes, yes. দেখাচ্ছে এই জন্যই তো সেকশন 8 মিলট the award was মিলট issued on 16 December 2020.
9% first component 1
Yes.
is 9% on the enhanced amount.
Yes.
Entire amount.
Correct.
Very well. 9%.
Then Milord 15% on the enhanced amount for Milord the rest of the period after 1 year till the award is actually paid.
But there should be two components here. One is till 30th of August 2018.
Then Milord adjustment has been Milord made here. Less received.
Suppose X amount was paid to you on 30th of August 2018.
Correct.
The interest will run on the balance amount.
Yes.
I mean the enhanced amount minus whatever was paid on 30th.
Correct.
Where is that calculation?
Milord, we have done it in some other way. Milord, we have first calculated our total entitlement. What would have been our entitlement?
9%
It
comes
would
on
Milord
that.
take us to the same Milord point. And then Milord
Does it?
less.
Does it? Check up. I'm very poor in mathematics.
Can't be Milord as poor as me. Milord, that is how Milord we have Milord. I have Milord done it. 9% on Milord the modified awarded amount.
Component 1 we have no doubt whatsoever.
2, my
Subject
lord
to
is having
calculation.
some doubt because my lord is of the opinion that Milord here Milord the adjustment was to be made, not Milord after that. That's what Milord is possibly passing.
50% on the enhanced amount.
Yes.
How do you calculate it?
আমি বুঝতে পেরেছি. My lord wants Milord to calculate this, Milord, after giving adjustment, Milord, to the amount paid, and then Milord to calculate.
The breakup in the sense that up to 30th of August 2018.
Yes, Milord.
Is from 21st of February 2018 till 30th of August.
It should be Milord at the enhanced rate.
15%. Enhanced rate, no doubt. 15% of enhanced rate. Up to 30th of August 30th of August 2018.
Yes, Milord.
15% on the enhanced rate.
Yes.
On the entire amount, whatever is due. I mean
Yes,
up to that date.
Yes.
Now some amount is paid on that date.
Yes. What was
then from 31st August 2018 till
11 June
11 June 2019, that 15% should be on the balance amount because that was only not paid. Why again 15% will be calculated on the entire?
Milord, I followed what is Milord traveling, your lordship. Milord, had I been paid interest, Milord, on 30th of August, the amount what was paid, Milord, would have been first, Milord, adjusted against interest. Then only, Milord, the principal could have been adjusted. That's, Milord.
Whatever you have been paid is only principal at both ends.
Yes.
Both points.
So, Milord, interest should have been adjusted fast then. Milord, if I calculate in the way my lord wants us, Milord, to calculate, Milord, I will be, Milord, held to be entitled, Milord, to a greater amount even, to a bigger amount even. Milord, I adjusted principal as principal. Milord, if I go by interest act and Milord calculate interest first and adjust Milord whatever I have got Milord towards Milord payment of interest, then Milord even the principal would remain due. Then Milord I would be entitled to a Milord a greater amount. That Milord we have not done.
Very well.
So Milord, this is Milord the yes, Milord, I have made over. Last occasion also Milord that was made over. My lord wanted Milord an Milord instruction.
Yes, Mr. What is? Yes, you are to take instruction.
Milord, my calculation is also there, Milord, and here there is a typographical error.
Apparently,
Milord, here, Milord, what happened? The Milord, the learned single judge, Milord, that did not calculate the interest on this, Milord, this amount from the date of Milord possession as alleged possession till the date of award. That is the 1 year 9%, and beyond 1 year 15%. So 1 year part is not added here. 9% from date of possession till the date of award, that is skipped here. That is only due and payable.
So,
Here will not charge.
Mr. Dole, please come to page 175.
Yes.
The petitioner is therefore entitled to interest on the amount awarded in terms of section 80 at the rate of 9% per annum from 21st February 2017 to 20th February 2018. That is 1 year.
Yes.
9% has been awarded on that.
So the Milord here the possession is say taken on 21st of February 2017.
Right. So
And
1 year ends on 20th of February 2018.
20th of February 2018.
Right.
So 9% will be computed.
That has been given on that.
Here. And then, Milord,
Yes.
beyond that, till the date of award, it will come 15%.
Absolutely.
So here, Milord, the
minus that amount which you paid on 30th of
already
August.
paid, minus that amount.
Therefore,
so here, Milord, kindly have this, Milord. It's very clear, Milord. I have prepared it, Milord.
You give a copy to them now.
Milord.
We'll give you 10 minutes to resolve the issue.
Milord.
We'll come back and then pass our judgment.
Should I?
Yes, yes, hand over copies to us also. But if it's the same thing, then we need not. According to their calculation, probably more interest. What is the total interest according to you, Mr. Drulia?
That amount is due, Milord. Interest on 2,80,084.
What is the amount? What is the amount
This
due?
amount 9% due.
What is the sum total?
Total amount will come, Milord, 25 lakhs around.
25 lakh.
Milord, that it is my calculation, but is subject to the Milord. This is the amount from the date of this Milord possession till the date of 1 year from the date of possession.
No, that is 1 year.
One.
What about the 15%?
That has been computed and paid. That has been paid, Milord.
There are apparent flaws. My lord will kindly come back. My lord, I'll immediately show. Apparent flaws. Okay.
Yes.
Kindly, my lord, take, my lord, Mr. Kaur is here. My lord, kindly take, with the leave of Mr. Kaur. My lord, with the leave of, kindly leave of Mr. Kaur. Kindly, my lord, kindly take these two computations, my lord, side by side. My lord, let us, my lord, have a look at, my lord, my learned friend's computation first. My lord, the first component under, my lord, capital A, my lord, my learned friend has calculated interest at the
There
rate.
is market value solution. These are
Well, those are not to be looked into, my lord. Ultimately, my lord, 12 crore 54 lakh was, my lord, the compensation amount, which was rather later, my lord, enhanced to 15 crore or not. So, my lord, today, there is no doubt, can't be any dispute with regard to the fact that, my lord, I am entitled to interest on 15 crore. My lord, 12 crore was initially, my lord,
the
awarded.
calculation is based on 12 crore.
Then, my lord, they have calculated it under C, my lord, for, my lord, this extra amount of 2 crore and 80 lakh.
Oh, acha, acha.
But, my lord, for, again, for a, my lord, lesser period. My lord, let us come to clause A of, my lord, my learned friend's computation. My lord, here, my lord, two mistakes have occurred. My lord, firstly, my learned friend has calculated interest from the date of, my lord, the possession. My lord, the award was passed, my lord, on 16 December 2016. My lord, interest is to be calculated, my lord, going by, my lord, the decision of R.L. Jain of the Honorable Supreme Court, of course, subject to correction, from the date of the award, which we have
So,
done.
but the section 80 says from date of
My lord, that is explained, my lord, in the decision.
side that
R.L. Jain টাই তো দরকার।
interest from date of possession is clear in the
Well, that's well explained, well, of course, subject to correction. এটা তো এসসিসি অনলাইন থেকে তো নিবি, এটা কোত্থেকে নিয়েছিস? লাইভ ল? This is Millard from Indian Canon. Millard, should I cite from SCC online?
Later. Later give us the citation and give a copy to Mr. Dhuli also.
Yes, at a copy. Millard, kindly turn to Millard paragraph 32 of Millard.
This is Bombay High Court.
Millard, this is Millard Bombay High
Special
Court.
bench of Bombay
Yes,
High Court.
but relies on Millard R.L. Jain, which Millard I have requested my learned junior Millard to. Millard, that is R.L. Jain is quoted here. Millard, paragraph 32, if my lords kindly take the trouble to have a look
Yes.
at. Keeping in view the entire scheme of the Land Acquisition Act and the ratio of decisions of the Apex Court in R.L. Jain Supra, the position of law can be summarized as under. Millard, then under number Roman 1, if the possession of the land under acquisition is taken under section 16 of the Act after an award is made by the collector under section 11, the interest would be payable under section 34 from the date of passing of the award, and we are in agreement with such a view. So, Millard, drawing inspiration, Millard, from this observation, Millard, in our computation sheet, Millard, we have calculated, Millard, the interest not from the date of possession, but Millard, from the date of award, which preceded, Millard, the possession.
This was under 2013 Act.
Yes, section 80 is no. This was Millard under Land Acquisition Act. Land Acquisition Act.
Section 34 parameter.
There the provision is similar.
Perimeter, yeah, Millard. Kindly, Millard, have a look at, Millard, these two provisions side by side. Millard, hand up. Even the rate of interest is same. কিন্তু টাইমটা আর অ্যামাউন্টটা আড়েল দিনটা আনা 49337. 9 SCC 33. Oh. What 4? Bullion. 2004 volume 4 SCC.
Under the 2013 Act, because this was under section 17.
Yes, Milord. Milord, kindly have a look at Milord, these two provisions, Milord, side by side. Milord, this is just Milord.
34 and 80 are similar.
Yes. So,
So
Milord,
here the court considered that under
section 80.
section 17 position was taken.
Correct.
Section 17 was an emergency. That is an emergency provision.
True.
So that
But-
provision itself contains a rider that 80% has to be paid immediately and all. So therefore, it had to be paid at the time of taking possession itself.
True. But Milord, if we are on the wordings of Milord 34 and 80, then Milord, these two provisions are
It's in
absolutely
isolation
parallel.
because here the Bombay High Court, we don't know whether it was quoted or not. If the position is taken under section 17, interest payable under section 34 shall start running from the date of position. That is one, Roman 1 of 30, para 32.
Yes.
If under section 17. So are the is position taken under the 2013 Act similar to section 17?
Milord, clause Roman I, Milord, of paragraph 32 of the decision we have just now cited, Milord, that does not speak of Milord section 17. Before Milord, it says that Milord, award interest is to be given Milord from the date of the award. It says if position is taken, the interest would be payable under 34 from the date of passing of the award. And then it says Milord, Milord discusses about section 17. But Milord, section 17 invocation of emergency provision is possibly Milord not a distinguishing feature, Milord, of course, subject to correction by Lordship. Because Milord, section 17 discussion comes later. But before that, Milord,
So that was in terms of a division bench of Bombay High Court itself. One.
Yes. It's Milord summarized. Adel Jain is summarized.
Adel Jain you have got.
Soft copy then আমার নেটটা খুলছে না মাইলটকে দে আচ্ছা দি প্যারাগ্রাফটা বলে দে যশ সাহেবকে দে প্যারাগ্রাফটা বল সাহেব
Well, give us a copy later on.
Very well.
এটা দিন দিন।
So, Milord, we are on the date of Milord, the starting point of Milord payment of interest first. Secondly, if Milord have a, again Milord kindly comes back to Milord clause A of my learned friend's computation. Milord, they are computing on 12 crore, Milord, for this Milord 9% period. Where Milord, they again went wrong. Because Milord, if I were ultimately found to be entitled to 15 crore as compensation, Milord, I was entitled to 9% interest on 15 crore.
You have taken the starting point on 17th of December 2016.
16 Milord, the date of the award. 16 December 2016 was the date of the award. The immediately preceding day was the date of the award.
All right.
Milord, page 95 Milord of our application is Milord the award. So Milord, firstly, starting point is possibly incorrect. And secondly, Milord, the amount on which Milord interest has been calculated, the principal amount under clause A is again wrong. I was entitled to 9% on the Milord total compensation amount. This number one. Number two. Number three, Milord, under clause B, again, Milord, this principal amount is Milord taken wrong.
Award itu principal ke যেটা যেটা হচ্ছে award যদি পাস করে তারপর তো কম্পেনসেশন পে করে যদি award শুরু করে পয়সা না award ডেটটাই দিলে জয়েনিং অ্যাওয়ার্ডে যদি পাস করে দিতে তাহলে ওকে ইমিডিয়েটলি কম্পেনসেশন দেওয়ার কথা ছিল না বলে ওই ডেট থেকে তাহলে পজিশন আর বাকিটাই এই ক্যালকুলেশন ইয়েস
Then if my lord kindly see C, under clause C, my lord, now my learned friend's client, my lord, is trying to cover up, my lord, the balance amount which was later on, my lord, awarded. But my lord, here when they are calculating, my lord, 15% interest, they are calculating it, my lord, from 21st of February 2018 till 11 June 2019. Whereas, my lord, under clause B, they, my lord, stopped the calculation on, my lord, 30th August 2018. So these are, my lord, the 4 mistakes which are, my lord, apparent. May, my lord, Mr. Kaur, my lord, take over.
Lord, although Lord, this argument goes against my client, but Lord, my reading of section 80 is, it is from the date of possession. Because Lord, it's a compensation which is paid in lieu of possession being taken prior to
being deprived of possession.
Yes.
But that's the compensation.
That's the compensation. So if I'm in possession up to a particular date, perhaps Lord, that will be reading it in a more I would say more broader,
more true to the statute.
So Lord, that's one thing. But rest of the argument, I think, is completely Lord unimpeachable, because Lord, the award amount is 15 crores and not. I am supposed to get 9% up to a certain date, and Lord, after that 15% from a particular date till the payment is made. So Lord, in my case, Lord, the possession is taken on 21st February 2017, and Lord, the ultimate payment was made on 11th June 2019. In between, Lord, there is a part payment of 12 crores, which is Lord paid on 12 crores কবে payment করলো?
So last payment not on 11th June, it was on
It-
11th November.
11th November.
November. সেটাও একটা এখানে ভুল আছে।
11th November.
ওদের ক্যালকুলেশনে ওরা জুন
I
অবধি
see.
করেছে, which
I
should have been till 10th of
No,
November.
that judgment also.
The learned single just says June.
Yes, June.
That's sync, madam.
That not right.
It was November.
না তো পেমেন্টে দেখাও ওইটা, জাস্ট পেমেন্টটা
We
দেখাও।
have the checks.
হ্যাঁ দেখাও।
How is 11 June?
Look, this is perhaps the check.
No, are these part of the record?
No, this is not part of the record, but Lord, payment has been made by them. So I don't think they are going to dispute the date of payment.
They will dispute everything. Ask Mr. Jolie.
This is
Are you disputing?
Lord, whatever the calculation is there, that
No, this payment.
this payment, date of payment. Date of payment. This is a check issued by the competent authority.
Amount is also tallied.
And this is 2 crore 80 lakh 84,000.
paid by 11/11. Yes.
11/11.
Yeah.
11.
11/11.
Oh, that is there, Lord, in the calculation
I
given
mentioned
by
in my chart, Lord.
my learned friend. He has referred it as 11/11. So Lord, I get 15 crores, benefit of 15 crores for the entire period.
No, in his chart it says 11/6.
Its charge says 11.
See,
No, paid by check
Paid
on the
by
right.
check, madam.
Lord, kindly
Right hand side. See, Lord, right hand side.
come down to
Acha.
2 crore 80 lakh, Lord, on the right hand
but they've calculated till 11th of
till
June.
June. 11 June. Section 80 টার একবার দেখা। Section 80 টার একবার আমার বইটা গেল একবার দেখা।
First Mr. Banerjee confused, then Mr. Dolia confused, then RL Jain confused, now section 80. So we hope you simplify things.
Lord,
We're looking up to you.
I simplify things is by saying, reading section 80, that Lord, it says
Section 80 by itself is very simple.
when compensation is not deposited before taking possession, then Lord, it will run till the time interest will run rate of 9% for the time being so taken possession until it shall have to be so paid or deposited. This expression paid or deposited is there. And Lord, then provided it says if such compensation part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date or expiry of the said period for 1 year on the amount of compensation. So, my lord, perhaps June is the date, Lord, when they have deposited. They are taking it because they have deposited. There is a gap between deposit and payment, which is for about a period of 5 months.
But language says paid or
deposited. So I can't dispute that.
Post-dated check যদি deposit হয় কি হবে?
It is only Lord physical deposit. Paid, of course, it's paid to me. That payment date is there. This is a check issued by the
If they
computer.
deposited from their part, Mr. Record, then we should.
Then, of course, Lord, I can't put my case higher than what the section says. But Lord, there is a gap of 5 months before the check is issued actually by the competent authority. So, my lord, that part your lordships may kindly take into consideration. That may not come under 80, section 80, strictly speaking, because they say that they have deposited it on 11th of June 2019.
Call it a deposit when the check was to be encashed in November.
That is the main thing. Lord, my learned friends kindly correctly points out that, Lord, if the deposit is on 11th June,
Can you call it a deposit at all? 3 বছর বাদের চেক দিলাম।
Yes, date of the check has to be taken.
that is my humble submission, because Lord, actual benefit received by me, I am deprived of the possession. So, Lord, that the date on which I get the actual benefit, that should be, Lord, inuring to my benefit. That should come in my. Now, Lord, this is reading of 80.
So how did the learned single judge arrive at 11th June?
Lord, 11th June, perhaps she has taken the date of deposit. Your
That must be
lordship,
evident from something. I mean,
11th June, I tell your lordship, they perhaps that she has taken it.
That was
That,
their case.
that perhaps was their case. 11th of June was perhaps their case. They said that, but not what the fundamental mistake that the court made, subject to correction by your lordship, is that, Lord, calculation was made on 12 crore 54 lakhs. That was not, Lord, right. In fact, it should have been calculated on the entire amount of 15 crores. 9% and then 15%.
ওদের opposition page 124 11 জুনটা ওরা বলেছে।
And of course, Lord, one thing I must say,
Page
that, Lord, that 12 crores was paid on a particular date. I should get, they should get benefit of that payment, 12 crore 54 lakhs. And, Lord, the rest of the amount will carry 15% from that date. I'll give your lordship the exact date. Lord,
the first date is 30th of August 2018, no doubt on that. That is the 12th.
first date is 21st February 2017.
No, the first payment was made on 30th
Yes,
August
30th,
2018.
correct, 30th August. So, Lord,
So that you have deducted in your calculations.
yes. So 15 crores, correct, your lordship is right. 15 crores will carry 9% for 1 year, and then, Lord, 15% thereafter. Then, Lord, 12 crores receive is credited, and then, Lord, balance will carry 15% until the date of payment. That is 11th of November. That is how the calculation should be taken.
This balance will carry, Mr. Kaur, but that 15% for the rest of the period has been calculated on the entire sum, apparently no.
No.
Only on the balance.
Only on the
Right.
only on.
Yes.
আর 11 জুনটা কেন? Because of this, they filed a report.
I'm told, Lord,
Not August, September.
It's September, 5th September.
You said August.
Milord, that is what they said. Milord, because of 5 days difference, Milord, we thought, Milord, it's
1 month different.
5 days difference, Milord, interest for 5 days. 30th August, they say, Milord, they have paid. The check was, Milord, issued on 5th of September. So, Milord, there was a time gap of 5 days only. Milord, we wanted to let it go. So, Milord did not travel your lordship after this.
So first, your section 80, your first point is this, it had to be on enhanced compensation. Secondly, this RLJ argument also we are taking. Because
Lord, it was done, but
there's a
I
Supreme Court
reading of section 80, Lord, I personally feel that maybe, Lord, the circumstances of that case I have not seen.
RL Jain will have to enter into then because it
RL Jain
will have to look into
Ekbar
that.
RL Jain. Kindly give me 2 minutes, Lord. Let me quickly consider RL Jain. Lord, first contention is that, Lord, section 80 was not at all allowed by the competent authority or the appellate authority.
No, that you are challenging this single judges.
Only to this effect. এখানে কি হয়েছিল পজিশনটা নিয়ে নিয়েছিল ইভেন বিফোর নোটিফিকেশন আন্ডার সেকশন 4
জজ সাহেব সেটাই বলছেন ইমার্জেন্সি প্রভিশন ইনভোকেশন
that is the main reason.
কিন্তু যখন লটা লে ডাউন করছে তখন আর সেই কথাটা বলছেন ইটস আপ টু ইউ আপনি যেটা ঠিক মনে
কারণ এটা আবার সুপ্রিম কোর্ট গেলে ঝামেলা হবে বুঝছিস তো এই জন্য ভাবছি let us end the matter here.
16 আর 17 ইমার্জেন্সি পয়সা হবে সার্কামস্ট্যান্সেস ছিল যেটা বলতেন
under the 2013 Act, position is it's like rest is like the LA Act.
Absolutely, my lord, para-material. It's in para-material.
There's an emergency provision like section 17 also.
I'll just check. I think so.
Forgotten actually.
I think so.
That this would then same logic should apply. In this case, acquisition itself was under 2013 Act, not under LA Act.
No,
then applied.
this is under Metro Railway, but Lord, 2013 Act is read into Metro Railway. This incorporated in the
Yes,
Metro Railway.
right.
So compensation is payable under the 2013 Act. Lord, I was just going through the judgment. Kindly take note of paragraph 17.1 and 18. This is the distinguishing feature. I'll just place it before. Paragraph
Emergency.
No, what happened was here before the notification under 4, the possession was taken. Even before the notification under section 4.
Yes, this was the second round of litigation.
The second round litigation. Kindly, my lord, take note of paragraph 17.1, where, lord, they say the normal rule, has your lordship got that? Therefore, is that if on account of acquisition of land a person is deprived of possession of his property, he should be paid compensation immediately, and if the same is not paid to him forthwith, he would be entitled to interest thereon from the date of disposition till the date of payment thereof. But here the land has been acquired only after the preliminary notification was issued on 9th September, as earlier acquisition proceedings were declared to be null and void in the suit instituted by the landowner himself, and consequently he was not entitled to compensation or interest thereon for the anterior period. In a case where the landlord is dispossessed prior to the issuance of preliminary notification under section 4(1) of the Act, the government merely takes possession of the land, but the title thereof continues to vest with the landowner. It is fully open for the landowner to recover the possession of his land by taking appropriate legal proceedings. He is therefore only entitled to get rent or damages for use of occupation for the period the government retains possession of the property. Where possession is taken prior to the issuance of preliminary notification, in our opinion, it will be just and equitable that the collector may also determine the rent or damages for use of the property to which the landowner is entitled, etc. The provisions of section 48 of the Act lend support to such course of action. For delayed payment of such amount, appropriate interest.
Different footing.
This was absolutely different.
The language of 54 and 80 is very clear.
Section 80's language is clear, and section 34 is equally clear. Here, my lord, something else had happened. Before the notification, my lord, the possession was taken, and that's why, my lord, the interest was allowed. Damages, interest, all this is allowed. Factually, this is
should be date of possession.
আর এটা জজ জানতে চাইছিলেন emergency provision আছে কিনা?
Lord, the emergency provision under the 2013 Act is, Lord, section 40. I think, Lord, these are my submissions. So only correct, we are seeking Lord correction.
So therefore, you have to give a fresh calculation sheet by taking into
From
account
the
the.
date of possession.
Yes, Mr.
My lord, here, my lord, the writ was filed, my lord, after, my lord, determination of compensation, and claiming therein, my lord, that the petitioner is entitled interest under section 80 of the 2013 Act, Right to Fair Compensation Act. So here, my lord, the section 80, my lord, the language of the section 80, that is, my lord, that when the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay amount awarded with interest thereon at the rate of 9% per annum for the time so taking possession until it shall have so paid or deposited, provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period 1 year on the amount of compensation a part thereof which has not been paid or deposited before the date of such expiry. So here, my lord, from the date of possession, interest is payable, my lord, on the amount of delayed payment. That is the 9% for the 1 year. And beyond to that 1 year, it is payable 15% till the date of payment. So here, my lord, it was stated that possession was taken, my lord, on possession was taken on 21st of February 2017. So therefore, my lord, the possession was taken 21st February 2017. So the 1 year comes to 20th of February 2018, and being the, my lord, date of the award, my lord, that amount is payable, my lord, till the date of the award.
The date of award was 16th of December 2016, before everything, before even possession.
First, before that,
this interest is an additional interest to compensate, as Mr.
Before that, my lord,
for the possession.
Before that, I place, my lord, that what is payable. That is, my lord, 113 in the paper book.
এই বইটা ফেরত দিয়ে দিন আপাতত।
This is the order of the appellate authority, my lord. This is the final amount was payable. I am placing that. 113 is the relevant. From where, my lord, I will start.
Yes.
In the middle, my lord, in the, as you lords got it?
Yes, yes.
In the review application, though there is no grievances in respect of calculation of solution from the end of the parties to the review application, in spite of the same, to correct arithmetical calculation, it is highly required to mention the amount of solution equivalent to 100% of the total market value of the case land in this order. The solution which is equivalent to 100% to the total valuation of the case land is of rupees 6 crore 27 lakhs 27,741 plus 100% solution of the same amount is 6 crore 27 lakhs 27,741. That is equal to that is the 12 crores 54 lakhs 55,482 plus 12% additional interest of rupees 2 crores 80 lakhs 84,464. So this 12% is, my lord, under section 33. That is, the my lord, 12% from the date of notification till the date of the award. And that amount comes, my lord, 2,80,000, 2 crores 80 lakhs 84,464. And total amount, my lord, coming to 15 crores 35 lakhs 39,946. My lord, during the proceeding, my lord, the petition was made to withdraw the amount. This amount, my lord, that is the admitted compensation and solution by the, my lord, the landowner. And that was allowed, and the amount was withdrawn, and the amount was paid. That is the date, my lord, I have given in the chart. That is, my lord, I'm sorry. That is, my lord, 12 crores 84 12 crores 54 lakhs 55,482 paid by check. Now, dated 30th of August 2018, deposited with the competent authority. So this amount was paid. So then, my lord, the additional amount of 12% per annum on the market value of the case land on and from the preliminary notification dated 25/3/2013 till the date of award passed by the landed competent authority, Metro Railway, Kolkata, that is the 16/12/2016, would be 2 crore 80 lakhs 84,464. So this amount was not computed when making computation, my lord. This amount is skipped. So this, my lord, on this, there are several proceedings were there. Ultimately found this amount is payable, 12%. So this is the computation, my lord, and the total amount came, my lord, 15 crore 35 lakhs 39,946. So out of this, my lord, this amount already paid 12 crores 54 lakhs and 55,482, and remaining amount was only payable. So, my lord, this chart, my lord, the remaining amount was paid. The remaining amount paid, my lord, that is the 2 crore 80 lakhs 84,764, my lord, paid by check on 11/11/2019 to the competent authority. So both the amount paid, my lord, the compensation amount, solution, and, my lord, the 12%, all the amount paid now, completely paid. Now the only question arose, my lord, payment of, my lord, interest under section 80 of the right to fair compensation as claimed, and that was granted by the learned single bench, granted that, and that is, my lord, kindly I am placing that part of the judgment, my lord. My lord, page 174.
Yes. Yes.
Have you got it?
One second.
My lord. My lord, I am not reading from the top, my lord. I am reading, my lord, from the, my lord, the 8th line from the bottom.
Yes. Yes.
The amount of compensation was assessed and reassessed by the authority as recorded earlier, and the admitted amount of compensation to the tune of rupees 12 crores 54 lakhs 55,482 was paid to the petitioner on 30th August 2018. No compensation or any part thereof was paid, deposited by the respondent prior to that date. Total amount of compensation was finally determined rupees 15 crores 35,000. 15 crore 35 lakhs 39,946, and the balance amount of 2 crores 80 lakhs 84,764 was paid to the petitioner on 11th June 2019. And here, my lord, date, here it is, the payment is 11/11/11. Then, my lord,
this 11th June should be 11/11.
11
November.
Yes. Then, my lord, it is crystal clear that though the possession of the land was taken on 21st February 2017, so this is the date, my lord, taken for computation of the section 80 interest. So though the land taken on 21st February 2017, compensation was paid to the petitioner on 30th August 2018 and 11th June 2019.
This should be 11th November 2019.
Yes.
June should be November.
No.
Yes.
So therefore entitled to interest on the amount awarded in terms of 80 of the Act 2013 is 9% per annum from 21st February 2017, that is the date of possession, to the 20th of February 2018, that is 1 year, and then at the rate of 15% per annum from 31st of February 2018 to 30th August 2018, insofar award amounting to 12 crore 54 lakhs 55 482 is concerned. So this was computed, paid, and is concerned. And from 21st February 2018 till 11th June 2019, insofar the award of 2 crores 80 lakhs 84,764 is concerned. Here is the that error. This amount has been interest computed only 15% after 1 year. So 1 year, 9% is not added here. That is the only lacking amount and due and payable.
For this 2,80,000.
Yes, my lord. Only this amount. And that I made my calculation, my lord, and made chart, my lord. So that I found this, I said in D, that interest on 2 crore 80 lakhs 84,764, that is the 12% which was directed to be paid, which not taken into account. So this amount, the Section 90 interest is due 9% from date of possession for 1 year. 20th
When was the award enhanced, Mr. Dolia? The original award was dated 16th of December 2016. When
24th April 2019. The reassessment by the appellate authority.
Mr. Dolia, shouldn't this 9% and 15% be calculated on the enhanced amount?
Yes.
Because 80 speaks about the award.
Yes.
Award should be the final award which is decided, which is the enhanced award.
Absolutely.
So therefore, this learned single judge directed this 9% and 15% on 12 crore 54,000 something. So shouldn't that calculation have been on 15 something? That is another question posed by the appellants. Because apparently this 9% up to 1 year, we can appreciate that also should be 9% should be on the enhanced amount, but that was calculated apparently on 12 crore 54.
The 12 crores amount that is already computed in A and B and paid. As per the direction of the Honorable Court, my lord, amount has been paid. That amount has been paid, my lord. Finally, it has been paid, my lord.
12,54,55 has been paid, then 2 crore 80 has been
paid. I paid, my lord, 12 crores 54 lakhs 55,482.
Yes. And then
second payment
2 crore 80.
2 crore 80 lakhs 84,764 paid by check, and then again I paid, my lord,
Again you paid?
Yes, the 2 crore 67 lakhs 10,477 interest under Section 80 of 2013 8 paid in terms of the order dated 14th of July to 2023. The single bench order.
When did you pay that?
That I in chart I have stated, my lord, just above to D.
Acha, 267 10 477, that?
Yes.
In June 2024.
Acha.
80 interest has been paid, except that part, 9% for 1 year. There was no direction of the court, therefore the Metro Railway did not compute that.
Both of you will request Mr. Cord and Mr. Dolia just put in 1 page, 2 page written notes of arguments so that we don't miss out anything.
Only the calculation. There's
no,
actually
even the points also, because on Adjournment, what is your final stand?
No, I absolutely final stand.
So we'll take written notes of arguments here, because
but I can't say Adjournment at all.
No, but you also consider Adjournment, Mr. Cord, if you see that there is something.
I very
Apparently, we are agreeing with you that Adel Jain does not. It was in the fact of that case.
That's my first impression about the judgment.
But there may be a second impression.
Very
So
well.
we'll take written notes of arguments next Thursday, Mr. Rolia and Mr. Kaur.
As you lordship, please.
So we have heard you substantially, and
Mainly that amount, 9% can be directed, and
But, we
Metro
need
will
to-
not withhold, my lord. This is that implementation, my lord, order of the court. That is not there. It was not.
No,
If
it's
your
a
lordship
legal
that
argument.
Will make clear.
No, it's a legal argument. Metro
Yes,
Railway
yes.
obviously will comply. We don't know that.
You will lordship.
But just put your argument on paper. I mean, written notes of arguments we'll take on next Thursday.
Calculation to recalculate.
Short notes.
Very
short.
bullet points.
Only with this amount, this part, my lord.
What? No, your logic for that. You just as you argued before us.
Yes.
That the basis of the calculation, the learned single judge was correct, or whatever you said, just put that in writing.
I will back out.
So, oral arguments are concluded. Full stop. The learned counsel, the matter shall next be listed on next Thursday. Yes.
9.
Yes. On April 9, 2026, under the heading to be mentioned for the purpose of filing of written notes of argument. It will appear at the top to be mentioned. Just
And Lord, the statement of account which I submitted before, Lord, is kept in the record.
very well. The statements of accounts filed by both parties to be Mr. Dolia, we are keeping it on record, but you furnish this with your written notes also. So it will be a composite. The same thing, just a soft copy, just take a printout and annex it with that also.
We need to correct our.
You need to correct yours if you take a different stand.
We'll correct.
We have taken this, but you annex this to your written notes of arguments also. This will take this as a part of your written notes of arguments.
As you lordship.
আচ্ছা তোর বই নিয়ে টানাটানি চলছিল আমার বইগুলো যে কোথায় গেল আমার বইগুলো
Yes.
But I am for the appellant hearing in this item number 6. But I am very much sorry that due to my medical ground, I could not present.
No, it's all right, Mr. Chaudhary. It's all right. No difficulty.
But the short points involved in this repetition in this matter.
Yes.
That a probate was granted by a competent court. When the executrix applied for mutation on the strength of the probate, submitted application for mutation before the authority concerned. The authority concerned, while rejecting that prayer by passing a very cryptic order, but challenging that the edit petition was referred before this honorable court, and being WPA number 27364, when the said writ petition was ultimately decided in favor of the respondent on the 30th of August 2024. Lordship, kindly take page 84, the impugned judgment of the landed single judge.
Probate was granted.
Yes. Probate was granted.
Very
good. Probate was granted. My Lordship will find in the paper book the probate at page.
Need not. If that is an admitted question, we need not look into that.
Lordship.
Yes.
There will find the impugned judgment.
Yes.
Of the landed single judge at page 84.
Yes.
Of the paper book.
Yes. Why was it refused? On what ground?
Only ground that the lease deed was not executed and registered by the authority in favor of the agreement holder. Before.
What is the order? Where is the first order, Mr. Chattopadhyay? Which was challenged before the writ court? We want to see that also.
Yes, Lordship will find at page 74 of in the paper book. Page 74.
That is also at page 56, same.
Yes. Lordship.
Watch, this is in the Kolani township. So a lease deed is required to be executed for transfer.
Lordship, there is no ipso facto bar in the lease agreement that the lease deed is required for executing a will. But I am
No, for executing a will definitely not, Mr. Chattopadhyay. But if your name is to be mutated,
yes, originally the land was allotted. A lease agreement was executed in favor of the original testator.
what according to the lease deed or whatever, the heirs are automatically entitled.
Yes, in the specific clause in the covenant of the lease agreement, there is a clause that if the lessee die intestate, can execute a will, or that can be
Let us start with that, Mr. Chattopadhyay. Let us start with that. Just that
Then you
clause.
also kindly take the page. Kindly take page. Sorry, madam. Yes, kindly take page 24 of the paper book.
24, yes.
No, page 25. Lordship, kindly take page 25.
Right.
There is a clause, subclause H.
Yes.
I will also got it. Should the lessee stroke lessees die after having made a bequest of the leasehold premises and the buildings to be erected thereon in favor of more than one person, or die intestate if having more than the heir, more than one heir, then in such case the persons to whom the leasehold premises with the buildings erected to be bequeathed on the heirs of the deceased lessee, as the case may be, he shall hold the said property jointly without having any right to have the partition of the same by metes and bounds, or they will nominate in person amongst their number in whom the same shall vest. Now, in the present case, my lord, that the lessee, namely Ramesh Chandra Dev,
bequeathed. You come under bequeathed. Yes.
Yes. And on the strength of a will, it was proper bequeathed. Thereafter, the will was probated by this honorable court. And in the said probate application, during the pendency of the probate proceedings, the heirs, the nearest, and the all the relatives of the testator submitted their consent affidavit, no objection affidavit, what is required by another law. So thereafter the probate was granted, and on the strength of the probate, the application for mutation was submitted.
Right.
And the probate was not sure.
Yes, Mr. Chattopadhyay. Yes, Mr. Chattopadhyay, let us just give us the date of the probate once.
Yes, not sure. If you automatically take page
2nd April 1991. 2nd April 1991.
91.
No, my lord. I stand corrected. This is the date of execution of the will.
This is day
Of the will.
March 2000, March in the year 2020. March 2020. Lordship will find at page 47. No. 7th day of February. The will was executed, last will, and the March 20, March 20, the probate was granted.
16th March, yes.
Yes. Now, thereafter, the application was submitted.
Yes, very.
And before the authority.
A single judge's order, Mr. Chattopadhyay. Let us come to.
Yes, but page 84.
84, yes. The testator himself, the allotment was not registered. There was no lease deed.
The lease agreement, there is no such covenant in the clause that for executing a will, a lease deed is required.
No, the testator himself did not have
No, the lease deed ought to have executed by the authority. The testator here, the testator was the lessee. The government of West Bengal was the lessor. The lessor did not execute the lease deed. Despite of taking the entire consideration value of the property.
But your right as the legatee cannot be, or executor cannot be better than the testator. If the testator did not have a valid lease deed in his favor, how can you claim a better right?
I put a question to myself, my lord.
Yes.
Whether a lessee or allottee or agreement holder of the lease agreement was whether there was an ipso facto bar that if there is no lease deed executed by the authority,
107 Evidence Transfer Property Act.
No, then my lord, the coordinate bench of this honorable court on the similar, very on similar point,
yes,
decided a matter of the very similar issue.
Yes.
Your lordship kindly take that is reported by
A copy was given on the last occasion.
Yes, 2024 volume 1 WBLR, page 126 to 130.
Yes.
That judgment was passed in view of the Kailas Kapoor of the Honorable Supreme Court. But my junior will there, he will hand over.
No, she has given. We already have a copy.
Yes.
Previously, it was given probably.
Yes. And it is my another submission that challenging that judgment of this coordinate bench, the state went to the SLP. The SLP was not allowed. The Honorable Supreme Court remanded back again to the authority for taking a fresh decision on the in respect of the right acquired on the ground of the probate obtained by the executor or the executrix. My junior will hand over the judgment of Supreme Court.
Probate 16 March na kota bolo? 16 March 2000 year of 2020. 20.
But in that case, there was a 999 years lease executed.
Here is also the same 999 years lease.
Lease is there. You say there is no lease?
No, the lease was there. Well, the lease agreement, allotment, everything is there. Well, if you're not saying again, kindly take trouble.
Formally, what is this then? Page 23, what is this?
23.
Oh, this is an application for grant of lease. Yes. No lease deed was formally executed, Mr. Chattopadhyay, in favor of the testator.
No, they have not executed, my lord. This is the application was the offer and they have accepted, my lord.
No,
So
but
the
no, Justice Boshak's division bench, there was a lease deed in existence. In your case, there
no,
was
there was no lease deed. There was also no lease deed in existence.
Where do we find that? Here, rather, para 13 of the judgment says subject deed of lease is for a period of 999 years. It vests the original.
That is the subject lease. There was also no lease deed was there. And my lord,
Subject of lease means the lease of deed, which is the subject of the litigation.
yes, my lord, but if you'll also kindly consider this aspect, that if what the learned other side, learned state, what they have submitted, that this is an application, what they have said, my lord. Now, if you'll also kindly consider their argument, their pleadings in their report, as they have submitted, my lord. If you'll also kindly take page. They have submitted the report and they have accepted that the lease is there.
What is that?
My lord, I'm sorry. If you'll also kindly page 62. Kindly consider page 62 of the paper book.
Start from my lord, page 60. 60. Our report.
They have stated in my lord, page 62, in terms of clause 4 of the lease agreement. So they have considered it as a lease agreement, not an application. And they have also annexed the copy of the lease agreement.
No, please see. This was an agreement, basis of lease agreement, not a lease deed.
No, yes, absolutely on the lease agreement, and I have already shown before your lordship.
Was directed to take physical possession of the plot, but he neither took physical possession nor paid annual rent.
No, but that is actually because in their order, in the impugned order, which was challenged before the writ petition, they took only one point: the lease deed was not executed.
Allotee has to mandatorily complete the terms and conditions by taking neither physical possession taken nor payment of lease rent.
Kindly consider the copy of the lease agreement.
You also have not produced anything to show you ever paid annual rent or took possession.
Yes, I have already documents were annexed in the writ petition. All the money receipts, lordship will find at page on and from page.
But the document which you showed, Mr. Chattopadhyay, starting at page 23, that is also couched as it starts with we beg to apply for the grant of lease.
Yes, that is the document they have also produced, and they considered the document as a lease agreement because the offer was made by the testator, and which was accepted. If you also kindly take only one paragraph.
Yes.
After I am showing the money receipts.
Yes.
Yes, my lord. If you also kindly take page. My lord, you also kindly take page 20. The copy of the said document, the internal probably page, it will be page 26. Also kindly see.
26.
Page 26, page
26 is a blank document.
No, page 25.
25 is a
deposit here with the such and such amount.
It's also a blank document.
It is a blank document, but that's the same document which they have submitted in their annexed with their report. That document was filled up document.
Please see the last line of page 25 also. Should you accept my offer, then please appropriate said sum. So this was an offer on your part. Application
offer
or
my part was that I have to pay the amount. So kindly see the page 27 onwards. The entire money receipts, the payment of premiums and salaries.
No,
From
you
time,
write your application, should you accept my offer, then please appropriate the said sum towards premium of salary.
yes, yes, and the
So this was
subsequent
an
on
offer,
the
not acceptance.
yes, page 27 is I accepted the offer, and page on and from page 27,
No, you gave the offer. Page 25, page 23 onwards is your application.
Application in the form of offer, and they have accepted.
Yes.
So they
Where
took
is
the
the
money.
acceptance? Where is the acceptance?
They took the money, my lord, on and
Acha.
from page 27. They started taking money from me, from the testator, sorry. Page 27, page 28,
Acha. Very well.
several money were there. And my lord, it is in the said document, in the offer acceptance document, it is specifically written as and when called for, take the possession. Again, if you also kindly take page.
Mr. Chakravarti, your microphone is disturbing. Please don't move away from the microphone. Your voice is cutting off. What did they say? Take possession?
But if you also kindly take again the last page of that document, at page 26, 25, clause 11. Clause 11. On being called, have you also got it?
Yes.
On being called upon by the government, we shall within a week have the lease deed executed and registered upon payment of the appropriate stamp duty. But in the present case, never called for.
So
No such documents.
Why didn't you prefer a writ petition against them for enforcing that, or took steps for enforcement of this? They have
Because they have refused by passing the impugned order. They took the stand that since the lease deed was not there, the application, the testator cannot execute the will.
The testator made this offer, paid the salary. Still, they did not execute any formal lease deed. So there was no formal transfer of title to in your favor. So why they did the testator never moved any court? He could have enforced this agreement saying that I have made my offer, made the payment, you have accepted. So execute a formal lease deed.
Yes, that's quite correct. There is no suit for.
Then there is no formal transfer of title. Your testator's name was mutated.
My testator's name was mutated in view of this lease agreement because the authority in their report submitted that the land was allotted.
Show us that your testator's name was mutated.
Mutated or allotted? The land was allotted. Yes.
No question of allotment. Show us that your that testator's name was mutated.
Unless the testator's name is mutated, why or allotted, the land is allotted, why they have took the money from him for herself?
We cannot proceed on conjecture.
Sorry, my lord. Here the only question whether the present executrix have got any right or not, whether the testator or testatrix is deceased, whether he was entitled to execute a will or not.
No, that is not the question. They are not raising that question. Even if he was entitled to make a will, he has made a will, you have got probate. And the learned single judge said that despite having a probate, you step into the shoes of the testator. But the testator himself it was initial allotment, no transfer deed being executed in favor of the testator. He never had any title in the property. So you claim to him you cannot get better title. That is the finding. We don't find any lease deed executed in favor of the testator.
My lord, only I am putting up only one question, my lord. From there, I am showing one document that the land was given to the testator by the authority, my lord. If you'll also kindly take paragraph, page. Sorry, my lord. Page. Yes, my lord. If you'll also kindly take page 71. a so-called notice was given to the issued in against the testator. Lordship, page 71, Lordship got it?
Yes.
Whereas the plot number such and such at Kulani measuring an area of such and such total was allotted to Sri Ramesh Chandra Dev, the testator or the lessee. As per the agreement entered entered into by him and accepted by the government on 29/2/1968. And
Mr. Chaturvedi will come back after 2 and continue with this matter. Yes, Mr. Chaudhary.
Yes, my lord. My lord, the coordinate bench judgment,
Yes.
which I have shown to your lordship,
Yes.
when the lordship was pleased to correct to observe that in that particular case, Honorable Justice Devanshu Prasad pleased to hold that the lease deed was there.
Yes.
But admittedly, there was no lease deed, and that's why the state preferred the SLP before the Honorable Supreme Court. And they took that point before the Honorable Apex Court.
Acha, let us see the Supreme Court judgment then.
Yes.
It must be reflected there. Yes. No, that is not the point taken there.
Since I appeared in that SLP,
Yes.
and I've got the copy of the SLP is not with me right now, but they took that point, man.
It just records the narrative that agreement was entered, then probate granted. Yes. But
Yes,
at
in
the
nothing-
same time, yes. First of all, the state had taken a different point. State had taken a point that the leasehold interest of the original reality itself was terminated on such and such date. Therefore, the subject plot stands vested. So they admitted that there was leasehold interest.
Here also, Malad, I am before rising, Malad, I am showing that they accepted my offer and agreement was concluded.
All right. And page 71 also.
Yes.
There they refer it as a lease agreement, but still a lease.
No, sir. I'm grateful.
So they refer to clause 9C of the above lease agreement.
Because that is the termination, but in the impugned judgment, in the impugned decision against which the writ petition was challenged, they did not take that point. That the violation of clause 9C, they took only one point. The lease deed was not executed.
Yes, yes, yes.
But for the lease deed, the testator since deceased was never point for.
71. Very well, Mr. Chaudhary. Let us see at the other side. Yes.
Absolutely.
Yes, Mr. Shamanta.
My lord, kindly takes up the lease deed itself, my lord. It's at 236. Starts from 235.
Lease deed is also annexed at page 23.
My lord.
Yes.
Lord, the next page, it's a type copy is there, my lord.
Which clause?
Clause C.
C, yes.
To construct the building according to the rules as may be prescribed and according to plans, elevations, designs and exceptions as may be sanctioned by the government or by any local or statutory authority in that we have within 5 years from the date and on default government shall have the right to resume possession of the land free forfeit all or part of the money paid by the provider and lessee may be given extension of time at the distinction of the government. But here admittedly on 2011 we served a notice of show cause upon him and on 2013 also. Even after that they did not comply.
No, but you did not resume possession.
Lord, what happened, Lord? The present writ petition was filed challenging for non-granting of mutation. Lord, my submission is, Lord, the person who is the petitioner before your lordship, he cannot have the better title than that of his.
No, cannot.
But
we are speaking about the testator's title only.
The testator have no title, Lord. He has no
Mr. Shamanta, let us understand this. Now, this lease deed this provided the last clause of the lease deed says, we are depositing such as, should you accept my stroke our offer, then please appropriate the said sum of rupees such and such towards payment of premium or salary or salary. Now they show proof of payment. You appropriated. Therefore, wasn't it your acceptance first? Secondly, the page 71 notice, it first of all refers to their document as a lease agreement. Secondly, relies on clause 9C. Now, please see clause 9C. Clause 9C says that if they don't start construction, then you'll resume possession. You resume possession presupposes that they are in possession. Therefore, two things. One is that lease deed itself, yes, albeit there is no registered lease deed, granted. But the understanding was, your understanding was also that this constituted a lease agreement, which is evidenced by page 71, this notice to the testator. So you say there's a lease agreement, you appropriate the sum as per the last clause of the agreement, that offer. So therefore you accept it. And you say that we will resume possession. You rely on 9C, 9C says resume possession. Or there is scope of extension also. So it's not absolute. This notice is not absolute unless you resume possession. Here there is no case made out by the state that you have resumed possession, Mr. Shaw. So therefore that notice was the stage up to which you went. By necessary conduct you might have extended, might not have. We are not bothered with that. But therefore you admit two things. Lease agreement was there. Secondly, resume. They were in possession because you want to resume possession. So if that be so, then why shouldn't the name of this person be mutated on the string?
The persons maybe were given possession, but Lord, as per the lease agreement, the agreement so speaking about, Lord, he must have constructed or have taken registered document.
That is a different point you are taking, but that permits you only to, that does not negate the lease deed automatically. That permits you to,
because we have taken the money, salami.
Salami. And you can resume possession. What is the effect of non-compliance? Suppose if you proceed on the premise, you did not revert.
It will
either you resume possession or you may extend it. So that notice itself is not. So let us set aside the.
My lord, may I suggest one thing, my lord?
Yes.
The lordship can direct the authority to rehear the issue, my lord.
We know what we'll do.
No, that's not.
No, we can make it clear. Make it clear. We will make it clear. And that is even without our clarification that the present appellant will be subject to the clauses of the lease agreement. That we can clarify. So you can take whatever steps against her as you could have taken against the testator. But otherwise, here both of you proceeded on the premise there is a lease deed and they are in possession. So therefore, you cannot resile from that position by for mutation. The BLLRO does not decide title.
Here, not the estate manager himself.
Sorry, the estate manager. Mutation will be by the
estate manager himself.
Oh, here estate manager
in the estate colony estate the colony.
Oh, colony, right. Himself. So the estate manager does not decide title, and we are not saying that title has been conferred by this, but that question is irrelevant here for this purpose.
Sure. I am on the premises that the lease deed was not executed formally, so he is not entitled because he cannot have better title than the office.
No, we are only deciding that. I mean, we are virtually deciding the title of the testator. Take your seats, both of you. Yes. The present challenge has been preferred by the appellant against an order of the learned single judge, whereby the writ petition of the appellant was dismissed. Full stop. In the said writ petition, the appellant complained that despite probate having been taken by the appellant in respect of a will executed by the original owner, one Ramesh Chandra Dev, who was the allottee in respect of the subject plot, the application for mutation made by the appellant was not allowed by the estate manager, development and planning department, government of West Bengal. For sub next para, learned counsel appearing for the appellant argues that by dint of grant of probate, the appellant stepped into the shoes of the testator, original allottee, and as such is entitled to such mutation. By taking the court through the provisions of the purported lease agreement, comma, learned counsel points out that in terms of the same, comma, the appellant, the testator stroke original allotee was merely to deposit 10% of the premium and salami as mentioned in the earlier clauses of the said agreement. Full should such offer be accepted, comma, the respondent authorities were to appropriate the said sum towards payment of the premium or salami aforesaid. Thus, comma, even if the said document is construed to be an offer of lease given by the testator, comma, by dint of acceptance of the subsequent payments made in terms thereof, comma, there was acceptance of the said offer on behalf of the respondent authorities. Learned counsel also takes us through several annexures, comma, which were before the writ court, comma, evidencing the payment of such salami and other and premium, salami stroke premium. Next para, learned counsel cites a division, a coordinate bench judgment of this court in the matter of Srimati Chobi Choudhury versus the state of West Bengal and others, reported at bracketed 2024 1 WBLR bracket Cal 126, where under similar circumstances, comma, the coordinate bench had directed mutation to be effected in respect of the legatee of the will of the original allotee. A copy of the special leave petition filed against the same is also handed over in court, from where it transpires that the Honorable Supreme Court affirmed the said decision of the coordinate bench. Next para, learned counsel further points out that vide letter dated November 26, 2013, comma, the estate manager, comma, Kollani Urban Development Department, comma, Government of West Bengal had written to the original allotee stroke testator, placing reliance upon clause 9 within bracket small c of the lease agreement. Thus, comma, it is contended that even the respondents proceeded on the premise that the document in question was a lease deed. Next para, however, comma, the learned single judge turned down the prayer made in the writ petition on the sole premise that there was no transfer of title as envisaged in sections 105 and 107 of the Transfer of Property Act in the absence of a registered lease deed having been formally executed. Next para, however, comma, it is contended that such premise was erroneous inasmuch as the allotment by way of lease in favor of the testator, comma, into whose shoes the appellant now steps in, comma, was affirmed by the respondents themselves by their conduct. Next para, learned counsel appearing for the respondent authorities submits that no formal registered deed of lease was ever entered into between the respondents and the testator. It is argued that in the absence of such deed, comma, the testator could not claim any title to the property and, comma, consequentially seek mutation. Next para, it is further contended by the respondents that by virtue of probate, comma, the legatee merely enters into the shoes of the testator. In the present case, comma, since the testator himself did not have title to the property, comma, the legatee is also not entitled to have a mutation in her name. Next para, it is next argued by the respondents that it will be evident from the notice dated November 26, 2013 that the original allotee stroke testator did not comply with the provisions of clause 9 within bracket small c of the lease agreement, comma, which mandates the allotee to construct building according to the rules as may be prescribed and according to plans, elevations, comma, designs and section as may be sanctioned by the government or any local or statutory authority in that behalf, comma, within 5 years from the date of acceptance, and on default, the government shall have the right to resume possession of the land and forfeit all or part of the money paid by the lessee. Full stop. Next para. By placing reliance on the said clause, comma, it is contended that the original allotee having not complied with the same and being subjected to a notice under the said provision, comma, the present appellant apostrophe's name cannot be mutated in respect of the property. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that prima facie, comma, the document of lease agreement relied on by the appellant is in the form of an application stroke offer for the grant of lease and, comma, by itself, comma, is not a lease deed as such. Full stop. Although the same contains all the relevant clauses associated with the lease deed to be given, comma, the same per se is not a lease deed. Full stop. Next para. However, comma, it is conspicuous that in the last paragraph of the same, comma, it is stipulated that should the allotee accept, should the respondent authorities accept the offer of the allotee, comma, the sum of premium or salami paid by the allotee should be appropriated. Full stop. Next para. We find from the documents on record that such payment was duly made by the original allotee stroke testator and accepted by the respondent authorities, comma, thus giving a seal of sanction to the lease agreement stroke offer made by the allotee, original allotee. Full stop. Next para. Even from the notice dated November 26, 2013, comma, we find two important features to evince. Full stop. First, comma, the document in question has been referred to as a, within double inverted, lease agreement, double inverted close, by the estate manager. Full stop. Secondly, comma, clause 9 within bracket small c of the said agreement has been relied on to contend that the same was not complied by the allotee. Full stop. Clause 9 within bracket small c contemplates that in the event no construction as envisaged therein is made by the allotee within 5 years from the date of acceptance, comma, the government shall have the right to double inverted resume possession, double inverted close, of the land and forfeit all or part of the money paid by the lessee. Full stop. Next para. Thus, comma, by necessary implication, comma, resumption, necessary implication, comma, if a notice of resumption is given, comma, it has to be presumed that as a precondition of such notice, comma, the allotee must be in possession of the premises of the plot in the first place. Full stop. Unless the possession was handed over to the allotee, comma, there arose no question of resumption of such possession by the respondent authorities. Full stop. Next para. The second important aspect in clause 9 within bracket small c is that the said provision, comma, per se, comma, is not does not absolutely terminate the lease between the parties. Full stop. Next para. We say so because in the self-same clause, comma, a rider has been provided that the lessee may be given extension of time at the discretion of government. Full stop. Next para. In the present case, comma, apart from issuing a notice alleging non-compliance of clause 9 within bracket small c to the original allotee, comma, nothing is on record to indicate that possession was resumed and stroke or whether the time for making the construction was extended. Full stop. Extension may be implied or expressed. Full stop. Since the possession was never taken from the original allotee, nor was the money paid by the lessee forfeited expressly, comma, it has to be assumed that the rigors of clause 9 within bracket small c were never invoked by the respondent authorities, despite a notice in that regard having been served. Full stop. Such a notice is merely a prelude to such action, which was never taken in the present case by the respondents. Full stop. Next para. Hence, comma, from the above discussions, it is clear that by the conduct of the parties, comma, both the original allotee stroke testator and the respondent authorities proceeded on the premise that pursuant to the payment made in accordance with the lease agreement, comma, the same was treated to be a document creating the jural relationship of lessor hyphen lessee between the respondents and the original allotee respectively. Full stop. Next para. The by dint of probate, comma, by dint of probate of the will of the original allotee, comma, the present appellant has stepped into his shoes and, comma, accordingly, comma, is entitled to all the consequential rights which inured in favor of the original allotee stroke testator. Full stop. Next para. Hence, comma, the stress given by the learned single judge on title having not passed in favor of the original allotee is a non-issue in the context of the case. Full stop. Next para. It is well settled that while mutating a property in the name of a person, comma, the concerned authority does not have the jurisdiction to decide title. Full stop. The estate manager, comma, while mutating the property, comma, is only required to see whether there is a prima facie case of entitlement to the plot has been made out and whether the possession vests with the person seeking mutation. Full stop. Next para. Since a notice was given by the respondents themselves invoking clause 9 within bracket small c, comma, treating the document in question to be a lease agreement, comma, it cannot be now argued by the respondents that no lease agreement was entered into between the parties and or that possession was not taken by the original allotee. Full stop. Next para. In a suit for declaration of title, comma, the passage of title by dint of a registered document might be relevant. Full stop. However, comma, within the contemplation of the jural relationship between the parties, comma, the strict rigors of the Transfer Property Act and stroke or the Registration Act do not apply, and such jural relationship is governed by the scheme under which the allotment was made in favor of the original allotee stroke testator by dint of a lease agreement, comma, which was construed by both parties to create a lessor-lessee relationship. Full stop. Next para. The coordinate bench, comma, in Chobi Choudhury Supra, comma, which was affirmed by the Honorable Supreme Court, comma, proceeded in similar circumstances to hold that the legatee of the original allotee was entitled to have mutation in her name. Full stop. Next para. The factual circumstances of the case is all the more evident from the narration of facts rendered by the coordinate bench as well as by the Honorable Supreme Court while deciding the SLP against the same. Full stop. Next para. In such view of the matter, comma, we are of the opinion that the learned single judge erred in law in laying too much stress on passage of title within the contemplation of the Transfer Property Act and the Registration Act without looking at the issue from the focal lengths of the parties as well as the trappings of the jural relationship created by the lease agreement, comma, coupled with payment of salami by the originality and acceptance of the same by the respondent authorities. Full stop. Next para. Thus, comma, the impugned judgment cannot be sustained. Full stop. Accordingly, WPA 2736, accordingly, MAT 124 of, FMA 1274 of 2025 is allowed on contest, comma, thereby setting aside the, where is the judgment? If you just please.
84. 30th August 2024.
84. Thank you. Judgment dated August 30, 2024, passed in WPA 27364 of 2023. Full stop. The estate manager is which respondent?
Respondent number 4 hearing.
So the respondent number 4, that is the estate manager, comma, urban development department, comma, government of West Bengal, is hereby directed to mutate the subject property in the name of the appellant as expeditiously as possible, comma, preferably within 2 months.
2 months, there are elections at the end.
Elections, that's why we are giving you 2 months. Otherwise, we would have given you 2 weeks. How was it?
Leave it to Lordship.
Very well. Preferably within 3 months from the date of communication of this order to the said authority. Mr. Chaudhary, also, we are giving them the time to prefer an appeal if they want. SL.
Well, only difference, well, I find that though judgment has been passed by Lord. But the Chobi Chaudhary, who has Supreme Court has rendered that the probate was granted before the termination.
Here, termination has not been not taken place.
We issued show cause for termination. That is,
we have discussed that.
But before
we have said that the
before,
mere notice does not tantamount to that.
But that's true. But here that notice was issued prior to the probate, and here probate was early.
Notice means nothing. You give a quit notice. You give a notice under Section 64 of the 97 Act. Don't take any steps. What happens?
Notice also can be termed defective.
Not only that, after the notice also you can extend the time.
That has not been done.
We don't find anything. So that's not absolute. Okay,
my duty was to
I'm grateful to Lordship. I'm grateful to Lordship.
You are arguing your case, Mr. Shaman.
Yes,
Thank you. Thank you.
I'm grateful.
Next.
Item number 7, Mr. Mohinur Rahman is appearing for the appellant, Milord. Due to illness, he was in hospitalization. Yesterday, he released from hospital, Milord. 2 weeks' time is needed to come.
Ground, I will be the last person to object. But Manoj, there for the last 6 months, the appellants are enjoying an interim order of stay.
We'll limit the interim order.
Yes.
An adjournment is sought on the ground of recent hospitalization of learned counsel appearing for the appellants. Next para, learned counsel appearing for the Union of India submits. Respondent stroke Union of India submits that the appellants, did you take adjournment? No, they did not take.
Previous occasion it was called a couple of weeks back once, but Lordship had made it not to take.
Have been enjoying an order, an interim order for 6 months. Next para, be that as it may, comma, keeping in view the nature of the ground on which adjournment is sought, comma, we adjourn the matter. The matter is adjourned till April 9, 2026. However, comma, we make it clear that in the event any further adjournment is sought by the appellants,
some more time, at least 2 weeks' time,
or the appellants fail to appear on the next date, comma, ex parte orders may be passed in the absence of the appellants. He has been released yesterday. So we are keeping it next week. We are giving him 1 week's time.
Doctor advised him to rest for some time.
Then you have to make alternative arrangements. Sorry. We are not putting that in our order, but you have to make alternative.
Good.
Yes.
8 Malord back to appear on behalf of the Malord appellant.
Yes.
Petition appellant, Malord. To the unit.
Who is the main party, union or state?
Actually, Malord railway authority.
Railway authority. Who is appearing for the union? You are enjoying an interim order, Mr.
Yes.
Who mentioned it? Let us see. You mentioning it?
No, opposition file করো, opposition টা তো আমাদের চেক করেছিল না, opposition file করোনি, opposition
Railway, we are waiting for you. We are about to send an invitation letter. Yes.
this
please
is
carry
my
on, yes,
affidavit in reply, my lord.
What is the affidavit of service?
Affidavit in reply. Because my lord, kindly sees the
Have you
last
filed
order
your
passed.
opposition? Have you filed your opposition?
My lord, we are relying upon the opposition report filed by the state, my lord, because we have nothing to say, my lord. actually. It is they will say whether that land belongs to me and
So, I have
extent
This
that
is the reply to that,
reply to that, my lord.
to that
Yes.
report.
No, my lord, state filed opposition.
Oh,
My lord,
state-
at least, my lord,
You have already filed your opposition.
Lordship,
opposition, I think,
I think it has.
Achhe,
first time, my lord.
you have forgotten whether you have filed. You don't find it. That's why. Might have given them a copy, but you don't find it.
It is not filed.
Lordship, then I have to take that because I'm not having the original opposition copy.
Achha, then we'll check up again. Might have been
Lordship,
there.
but just few,
Might be there. We are missing out maybe.
because I have solved it and everything is, I am having the Xerox copy, but
No, Xerox copy won't
yes,
do.
yes, I have about to file that original copy.
Not filed. So you take back your reply. Reply for the opposition and reply. nahi.
My lord, kindly sees the last order, my lord, the affidavit in opposition, my lord, your lordship directed for limited purposes, my lord, kindly says.
Shall file their opposition.
Yes.
No recording that they have filed.
They have not filed, my lord. After that,
Then
my lord,
keep
it
it
is
with you.
appear.
Keep the reply with you. You yes.
And my lord, paperwork file, my lord, kindly record it.
The paperwork is there.
Yes.
Yes. What is the matter, Mr.
Yes.
Voter?
Actually, my lord, the mother of the petitioner.
If both of you please take your seats, we'll.
My lord, sorry to interrupt, my lord, but that reply is very important. If your lordship sees with your lordship.
If you don't, if the state doesn't stop.
Sometime, Lordship, because
May I clear?
Upon their reply, my lord, because the.
May I clear, my lord, it is incorporated in the paperwork, my lord. That their opposition has
You
been
cannot look
incorporated.
into it because if they have not filed in the opposition, how can you look into it?
Lordship, then let me take some time, Lordship, because
So Thursday.
yes, because
We'll keep it in the monthly list of June. You are enjoying an interim order, but you are responsible. What short passover? Very well short passover. Short passover.
Will be able to do.
Lordship, next week, Lordship, on
At
next
least we are not
Thursday.
granting time in any event. 2 cases of hospitalization we have granted time.
No, I'm ready.
So since you are not in hospital, no time.
No, Lordship.
We don't want you to be, but that is the rider. That is the only ground on which you have adjournment.
Lordship, I'm just the original copy. I'm having the original copy. It's in the brief.
What is the matter about?
Yes, my lord. Mother of the petitioner, my lord, was the owner of a plot of land that is, my lord, RS plot number 2246 of Mauja Dulia. That is, my lord, 11 decimal of land. My lord, in the year 1961, my lord, exact date is not, my lord, I cannot recollect, but in 61.
What happened?
61, my lord, a notice and a gazette notification was published one under section 4
of
by the
land
of the Act 1 1894. Thereafter, my lord, six notification published under section 6. The land of the mother of the petitioner was excluded. Thereafter, my lord, petitioner the
more it was there, but in 6 it was not there.
It was not there. So, my lord, suddenly in the month of, my lord, after the COVID, my lord, railway issued a notice, stop work notice, because the petitioner was, my lord, raising hotel over there in the plot of land. My lord, immediately, my lord, I filed an RTI application, under which provision, my lord, my lord. Now, state authority replied that regarding that LA case number, which has been published in the 1961. And also said that in the section 4, your land is there. So, acquisition proceeding was not completed in respect of the land of the petitioner. Thereafter, my lord, I came before this honorable court for against the, my lord, stop work notice. And this honorable court relegated this matter to the railway authority to decide that it has come.
You reply us.
Now, railway authority says it is the land of the railway authority. I don't know, kindly sees that reasoning they have
just give us the facts
without any documents. Says because the adjacent plot of the lands were acquired, so your land also
you challenged that stop work notice before the writ court.
Stop work notice.
That was dismissed, the writ petition.
No, it was relegated to the railway authority to decide my representation.
That you have challenged.
That decision I have challenged.
On what ground? It has been relegated to the railway authorities.
Yes, the railway authority now in the decision they have taken this is the land of the railway authority without any documents, my lord. They are referring.
Have you challenged that in any separate writ petition?
In this writ petition, I have challenged.
We asked you, you said you have come up against the remand order, the relegation order.
Yes, my lord, because railway authority decide this is the land of the railway authority.
First, the writ court relegated it to the railway authority. You have not challenged that order of the writ court.
No, that order you
not challenged. Subsequently, railway authority said it's their land. You have challenged that in writ.
Yes.
The writ petition was dismissed also this time also.
This time also dismissed on the ground that the entire land was acquired under the Defence of India Act.
What is your ground of appeal?
No, my lord, I am coming, my lord. In the reply, they have stated, even if, my lord, I assume that their statement is correct, although, my lord, no record has been, my lord, they have filed with or annexed with their, my lord, opposition, that only 0.02 acre was, my lord, acquired under the Defence of India.
This is the state's
version. That is the version of the state now. So, learned single judge proceeded that the entire land, that is my 11 decimal land, was acquired under the
railway
defense.
Takes a defense that they have acquired the land
under the Act 1.
Under Act 1 itself.
And under by that notification.
So, Defense of India Act, you say?
Because in the writ court, a new stand has been taken, has come out, that states said that the land was acquired way back during the World War II under the Defense of India Act. Well, kindly now, this is the impugned order.
They have produced a notification to that effect. Defense of India Act notification?
Only 0.02 acre. Even they are malad.
Let him complete.
Even they are malad kindly turns to their malad opposition. Today they have filed malad.
What is the total area of the land?
11 decimal. Prepare book to result.
Yes, which page?
Kindly turns to page volume 3, page 316.
No, opposition. You have got their opposition. It's
Yeah, I'm coming. In their opposition, they have stated. Well,
no, it's there in the paper book also.
It is also incorporated.
The reply is also there in the paper book.
Yes.
Yes, page.
Their opposition starts from page 325, volume 3, Malad.
325, yes.
Yes.
Yes. It was 0.02, Mr.
Yes.
Kodak.
O, last paragraph, Malad. O, small o, hence it is submitted.
Yes.
Hence it is submitted that there is evidence that 0.02 acres of land in RS plot number 2246 of Mauja Dulia was acquired permanently and handed over to the requiring authority. An award was declared and payment was made. Thus, claim of the appellant that it was not acquired at all is not true and liable to be dismissed. All right. So, even if, my lord, I am assuming that this is correct.
The
stand
rest
of the
remains.
state.
The rest remains.
Rest remains.
Very good.
So, railway cannot. Another thing is that, my lord, this land was acquired during the World War II for, my lord, development of, my lord, road of Morigam project, my lord. It cannot go to the railway authority.
But do you get that Morigram project and all?
Yes.
That notification has been produced.
Yes, yes. That notification is there, my lord.
What is that?
That is page 372.
What is the plot number? Your plot?
2246. RS plot number 2246.
What was the CS plot corresponding?
CS also my 2246. It appears from this notification, it is for Howrah Morigam project, my lord.
Where is your plot in this?
It's not there. They are referring the land, my lord, compensation disbursed to this, my lord, or to the owner of this lands, my lord. So I am not on that, my lord. 0 point at the base, my lord. State is saying, my lord, 0.02 acres of
No,
the
no,
land.
you have to be on that because if your plot is not covered by this notification, then there was no acquisition at all.
Let them show this. My name is there. I am saying this. My name
Apart
is not
from
there.
this, nothing was shown regarding that acquisition under Defense of India rules.
In respect of, my lord, RS plot number 2246.
Nothing was shown.
Nothing
This
has
does
been
not
shown.
contain anything regarding that.
Yes.
Very well. And nothing was shown in respect of Section 6 declaration regarding this plot.
No.
There was a Section 4 also.
My lord, there is a declaration, my lord, acquisition that in respect of only 0.02 acre, they have stated.
No,
that is my
Defense
payment.
of India rules.
That is, my lord, regarding the payment, my lord, compensation, my lord. So far, their stand.
You said that there is a Section 4 which included your plot. Section 4 notification.
Section 4 of the Act 1, not under the Defense of India.
No, Act 1, we are speaking about that only. We are done with this. Defense of India does not continue your plot at all.
Yes.
So the other notification, where is that?
That is coming.
Section 4 of LA Act.
Yes.
Act 1. And the Section 6 also we will like to see.
Yes.
Because you said it did not
Yes,
contain
yes.
that.
Volume 2, no? This is in volume 1, my lord. Page 78. This is 4 notification. Your lordship will find the land of the writ petitioner is in page 80. 2246. Schedule B. Page 80, volume 1.
Two 2246.
The sheet will be, my lord, page 80.
Yes. Right. And where is the section 6?
Section 6 is the very next page, page 82. It's not there. 2242 to 48 is there, but 2246 is not there.
Yes.
Now, my lord, kindly comes to page 87. This is a reply. Against my RTI.
No, what was the public purpose mentioned in this? Let us see that also.
Yes, that is very.
That is also important.
Yes, important.
This is also for
Railway
construction
project.
of Dankuni link project.
Yes, that is railway project, my lord.
That is a railway project. Very good.
Yes.
So this is for railways. But
Yes.
your plot is not there in the section 6.
Yes.
Very good.
Even, my lord, when, my lord, I applied under the RTI Act regarding the information of the acquisition when they demanded the land railway.
Yes.
Kindly see the reply of the state authority, page 87.
Yes.
Only, my lord, I am, my lord, contents of this, my lord. With reference to the above, this is to inform you that the above mentioned plot had been notified in Calcutta Gazette number 22nd August 1961, white notification number Howrah, so white notification Howrah, August in the Calcutta Gazette under LA Act 1 of 1894. That is, my lord, section 4 notification. So, admittedly, my lord, and undisputedly, my lord, acquisition was not completed in respect of the land of the petition. Now, my lord, kindly comes to the decision of the, my lord, railway, which I have, my lord, assailed before the land is single judge.
Yes.
For sure. Decision, railway. This is in volume 2, my lord. Sorry. Page, volume 2, my lord, page 183. My lord.
Yes.
That I am the divisional engineer. As you also got it, my lord.
Yes, yes.
And I am the divisional engineer of the east of the Southeastern Railway, Kharagpur, and the respondent number 4 in the WPN number so and so, and as an authorized officer by the Ministry of Railways, by Railway Board Circular number such and such, as well as the senior superior officer of the respondent number 4, assistant divisional engineer who is not empowered under the above Railway Board circulars. In pursuant to the Honorable High Court, Calcutta order dated 26/2024 passed by the Honorable Justice C. Gorankant in WPN number 11409 of 2024, the personal hearing had been conducted by the undersigned on 29/2024, 16/10/2024, postponed to 20/11/2024 and 28/4/2025 with you and your legal representative and dealer of court cases of the railway. This reason order is based on all your submission and all the available office records, correspondence, papers, documents found up to the last personal hearing dated 28/4/2025 in connection with CSRS plot number 2246 corresponding to LR port number 2278 of Mouda Dulia of GL number 35, Police Station Sakrail, District Howrah. That I suitably examined your representation dated 14/3/2024 being the annexure P10 in the writ petition number such and such with all of your further representation letters. It said your written notes of argument dated 29/2024, letter dated 3/4/2025, 25/4/2025, including all the documents submitted therein. And I also suitably examined all the available office records, paper, correspondences, documents up to 28/4/2025, including the statement with all the concerned gazette notification showing all the surround acquired CS DAG numbers of CS DAG number 2246, JL 35, Mouja Dulia, Sakrail, Howrah under Section 6 of the Land Acquisition Act 1894. B, copies of the specimen gazette notification indicating showing the norms of any transfer of the government lands for cancellation, relinquishment, transfer, modification, erratum, etc. for the several Moujas as published through various gazette notification, including one erratum published through gazette notification dated 6/12/1963 against the previous declaration under gazette notification number 17004, LA dated 16/10.
Yes, Mr. Godagutta.
This is not relevant with the Malad land also.
They say that railway officers, they say that it was found in the records that it was in the name of in the records of the state, it was in the name of the Southeastern Railway.
Yes.
But what records is not referred apparently.
Yes.
But on the other hand, it said that you have not produced documents to
Yes,
show
yes.
the gazette notification. What? How did the learned single judge do?
Yes. You will not. I think you noted. $259, my lord, page. This is the narration of fact, my lord. Reasoning,
need not.
From page 7, my lord, kindly consider. Page 261. Drawing attention.
7 is 265.
Paragraph 7, 261.
Paragraph 7.
Paragraph 7. Sorry, paragraph 7 of page 261.
Yes, paragraph 7. Drawing attention.
And drawing attention to page number 81, 82 of the instant writ petition, it is submitted by Gotagata that form the copy of the memo dated 15/12/2022 as issued by the Special Land Acquisition Officer General. It would reveal that the person to a query made by the writ petition under Section 6 of the Right to Information, the said SPIO informed that the aforementioned plot of the land was notified in the Gazette via notification numbers, so as such as which, according to Mr. Gates, notice under Section 4 of the Act, a copy of which has been annexed at page 72 to 76 of the instant writ petition. At this juncture, Mr. Gota, attention to page 77 to 79 of the instant writ petition, being the Gazette notification dated 26/10/1961 as published under Section 6 of the Act 1/1894. It is submitted by Mr. Gotagura that from the said notification under Section 6 of the Act 1/1894, it would reveal that aforementioned plot, which was the subject matter of the instant lease, was kept outside the ambit of the said notification under Section 6 of the Act 1 of 1894. Now, my lord, kindly consider the submission of the state. This is very relevant, my lord. Paragraph 14. It starts from paragraph 14.
Yes, yes.
Par contra, Mr. Dhod, learned senior advocate for the respondent state in course of his submission, so request this court to peruse the page number 9, 10, 11 of the report as submitted on behalf of the respondent state. It is submitted by Mr. Dhod that on careful perusal of the photocopies of the notification dated 7th, 8th May 1943, copy of which has been annexed at the page number 9, 10, the report as submitted by the respondent state, it would reveal that after initial acquisition under Rule 75A, Defense of India rules, the said requisition land, including the land in question, that is RS plot number 2246 in Mauja village, Zulia, was acquired under Rule 75A2 of the Defense of India rules by the Aden provincial government. It was the stand of the state that enter land was. It was submitted by Mr. Dhod that it is a specific case of the respondent state that the aforementioned RS plot number 2246 corresponding to LR plot number 2278 of Mauja Dhulia under PS Sakrail was acquired in connection with LA case number 2 of 1943-44, and the said plot of land stood vested with the state, and the same was handed over to the requiring body on 24/3/1943, as would be evident from the annexure A3 of the said report at page number 7. It is thus submitted by Mr. Dhor. By no stretch of imagination, it can be said that the aforementioned plot of land has not been acquired as strongly contended on behalf of the writ petition. Mr. Singh, learned advocate appearing on behalf of the Railway Authority, adopted the argument of Mr. Dhor on careful perusal of the entire materials as placed before this court, and after considering the respective submission of the learned advocate for the contending parties, it appears to this court that on behalf of the respondent state, sufficient material have been placed before this court, supported by affidavit to establish the virtue of a gazette notification dated 7th and 8th May 1943, plot number 2246, corresponding to LR plot number 2278 in Mauja Dhulia under PS Sakrail district, Howrah, was not only requisition under the Rule 75A of the Defense of India rules, but also the said land was acquisition under the Rule 75A2 of the Defense of India rules by the then provincial government, and further the said land was also handed over the requiring body by executing the document, which has also been annexed with the report submitted by the respondent state. In view of such, this court thus finds no merit in the case of the writ petition that the aforementioned plot land was not subject matter of acquisition in a proceeding under Section 6 of Act 1 of 1894, since, as indicated herein, prior to the publication of notice under Section 6 on 26/10/1961, the aforementioned plot of land already stood vested with the state by virtue of the aforementioned notification dated 7th and 8th May 1943 under the relevant provisions of the Defense of India rules. In view of such chronology of events, this court has got no hesitation to hold that neither the writ petitioner nor his deceased mother, Sushila Devi, has got any right, title, interest over the land measuring about 5 kata 19 chitaks 12 square feet in the said plot of land as claimed to have been purchased by virtue of 2 registered deed of conveyance dated 9/4/2012 and 2010/2014. As I've
it was your writ petition, the writ court has also directed removal of encroachment.
Yes. That
is
portion
beyond
has been
the
stayed by your lordship. So, now, my lord, kindly consider the report.
So if we got it correctly, Mr. Gotavadu was just repeating what he was saying. Page 372, we find the Defense of India rules, that notification.
Yes.
First of all, that does not depict your plot. Your plot is not included, one. Secondly, it was for
No, that
widening.
is regarding the payment of compensation. That page. So for the notification is there, my lord. Only, my lord, I will show, my lord, that is only 0.02. Was
that was that is their admission. Apart from their admission, it's
that is their stand also in the
stand. But from the records also, we find that.
Yes, 0.0.
Which page?
Yes, my lord. In their report, my lord, they have.
No, not their report. That notification is there.
Yes, yes, it is.
It was there.
Yes.
Report you have seen, page 372 probably. Or 332. 332 is their opposition where they say this.
In the read code, they have filed one report. The first one, second one. The handwritten, let's see.
Missing missing to page 80.
Page 196, Malot, volume 2, Malot, page 196. It tallies with the report, Malot, opposition filed with the state authority.
This was not under the Defense of India rules.
Yes.
This was under the Defense of India rules.
Yes.
Page 8081 was not.
No.
So 8081, page 8082, that has been given a go by.
Yes.
Basically by them
Yes,
also.
yes.
So it's now focused on Defense of India.
Yes.
Which you say was for
only for 0.02 acres, my lord.
That was also for widening of road.
That is completed, my lord. That is, my lord, your lordship.
Not railway, not railway.
Not for railway. Now, my lord, railway says, my lord, he relies on this report of the state. Now, railway has to show that how the land comes to in their hand.
কি বলছেন? আর এটার corroborating ইয়ে হচ্ছে আপনার ওই 372 তে একটা দেখলাম।
372 is the, my lord?
Yes, 372 is which one?
Is the payment of compensation page, my lord.
Yes,
370, according to them.
This does not contain your plot.
Yes. And in their opposition, they have also stated the partly was acquired.
Yes, they say specifically 0.02.
Yes.
So page 196 corroborates page 332 their opposition statement.
Yes.
0.02. Yes.
So my lord, two things, my lord. One is that, my lord, today, my lord, railway cannot claim over the property of the writ petition. Second is that, my lord, so where the stand of the state is concerned, my lord, state cannot claim, my lord, more than 0.03.
Yes. Who first, state or?
Statement. Still, we are dependent on the statement.
Yes, obviously. You have adopted there, you're adopting here also. Quick, Mr. Dhar, don't take so much time.
Yes.
You have finished by now.
Lord, I appear for Union of India with Mr. Singh, who is physically present before your lordship. Lord,
we can't lip read. We have to see your face also. Put the camera in a proper place. Yes. Mr. Rai. Oh, you are Mr. Rai.
Yes,
Then
sir.
please be a little bit tech savvy. Please learn from your juniors.
I would have learnt it from your lordship.
No, no,
Times.
you have not at all learned it from me. Then it would not
Now-
have been this. And now you're laterally, yes.
Now possibly your lordship.
Now,
I am.
yes,
I'm,
Mr.
yes.
You're
Lord,
visible.
in fact, Lord, in this matter, Lord, I appear for Union of India
Right,
with Mr. Guddu Singh.
Mr. Guddu Singh is
I'm
here.
being-
Yes.
Yes, who is physically present before your lordship.
Right,
Lord,
right,
I'm
right.
being ably assisted by Mr. Singh. He is better prepared than me in this
All right,
matter.
very good.
So, Lord, I will
Let us hear
definitely
Mr. Thor. Mr. Ram, let us hear Mr. Thor. Yes, Mr. Thor.
Yes.
0.02. We don't find anything more. What is your argument on that? If no argument, then let us pass out that.
Even I must be candid.
And you adopt this.
My lord, there is one point here, my lord. There's a checkered history of this case, my lord.
Not interesting. Only geography.
No, my lord, with
0.02.
my lord, with 0.02, my lord, as my learned friend said that we do not have right to demolish the plot, whatever the
Don't
construction.
have anything. That was for widening of Morigram road. Nothing to do with railways. Regarding railways, Mr. Singh, we could only find one section 4 notification under this Act 1, subsequently followed by section 6 declaration, which does not contain his plot at all. So there are two sets of initiation of acquisition process.
My lord.
One is under section regular LA Act.
And one is under Defense Act.
Under Defense of India. So you have a better case in Defense of India rules.
My lord.
Because that speaks about railway project, link road. But there only we find 0.02.
My lord, that is the link road where we are there, my lord. Railway is there.
But the area of the plot is total area is 11 decimal. Now this is 0.02.
My lord, kindly appreciate this, my lord. We are part of that link road, my lord. That is the railways project, my lord. So in any case, my lord, I am well in that picture, my lord. And my lord, by the order of the Honorable High Court, my lord, I was directed to check all these acquisitions, my lord, which the petitioner is also a part of this, my lord.
Mr. Singh, the High Court's order does not clothe you with jurisdiction if you did not otherwise have authority in law.
My lord, this is the authority which have been checked, my lord. The state has confirmed, my lord, that I am, even if the worst case I have, my lord, I am the owner of 0.02, my lord. And
let us come to that notification once. Let us not argue on thin air. Let us come to the document. Page 372 is that document. One is page 372, the other at page 196. So if you go by 372 is not very clear on that. That's under Defense of India rules. But 372 does not contain their plot at all. That is regarding payment of compensation. Now let us come to 196 of volume 2.
Difficulties, let me clarify, my lord. Kindly come to page 372 once.
Yes, we are there.
Yes. My lord, on top, my lord, will find that LA case number 2/1. So there are so many LA cases, 2/1, 2/2, 2/3, 2/4, 2/5. My lord, I must be candid. I could not lay my hands for all the LA cases. I only, my lord, got this 2/1 and few others. So this is an old document of.
Moreover, Mr. Singh, the burden was on the railway authorities because the officer concerned proceeds on the premise that they failed to prove any document regarding their plot not being there. So that's a negative proof. And it proceeds on the basis that you had submitted, your officials had submitted that the records of the state show that you have ownership of that plot or whatever. It has been allotted to you.
My lord.
So now therefore you are dependent on the state even before the authority. The state says this and produces this. So it's your burden and your onus, either directly or through the state, to produce these documents. So you must have been more vigilant because it's your property which is going. So you must have inquired from the records. You could have taken out an RTI from the state or whatever, or gone through the records, given inspection.
Whatever
Can't rely fully put your body on the state.
what is falling from your lordship.
Yes, you have produced nothing, precious nothing except the 0.02.
My lord, this is a fact, my lord, that, my lord, we did not have any documents. That is why we were dependent upon the states, my lord. And it is
Understood.
the state who has said that this land has been allotted to the railways right in under the defense rules, my lord.
Yes,
1943,
right. But we don't find anything, any reference to you. See this, where is the property? Where is the notification regarding this Defense of India under that Defense of India rules, Mr. Dhar? We don't find any notification as such.
Yes, yes.
Page 196.
Yes.
That is straightening Howrah Morigram Road. It does not speak about any link also.
Defense of India rules, Manad, the Union of India is the requiring body under the Defense of India rules.
Maybe.
And the purpose, Manad, for the purpose of the Defense of India. It could be for the railway, it could be for the link road.
Precisely, it could be for, this is for road.
Yes, this is particularly for
straightening Howrah Morigram Road.
Yes.
It's not a railway line or railway property.
Commuting the ammunitions for the, that could be the reasons. So we do not know.
Whatever may be the purpose, you build a highway to take to ammunition to the border areas. Fully understood, which is necessary also. But that stretch of road does not belong to the railways. If you said army, we could understand. Railway, how can the railway have any authority over that stretch of road which takes ammunition from the railway yard to the border or vice versa? I mean, the stretch of road belongs to the union, yes. But how can the railways have anything to do with it? It has to be mentioned somewhere. You see page 193, everything, whatever documents are before us. হ্যাঁ ওরা তো কনস্ট্রাকশন নোটিশ দিচ্ছে সেটার জন্যই তো সেটা তো ইনিশিয়েশন অফ অ্যাকশন রেলওয়ে নোটিশ দিল স্টপ কনস্ট্রাকশন করে তার জন্য ওরা
kindly come to page 190.
190, yes.
There are lands required for widening roads and for taking earth by
Which part of it? 190?
193.
193?
193.
Yes.
The land
for military purposes.
Yes.
Since when did the railway become military?
Military purposes, Manad.
Railway is not the military. Railway is not the army. These are two separate wings.
My lord, at that period of time, my lord, it was used for this. Thereafter, the land has been given to railways.
That we don't find any corroboration anywhere. We don't find the involvement of railway
My
anywhere.
lord, this is the advantage the petitioner has taken.
The purpose,
You'll get the advantage from us also.
The purpose, may I? If the purpose is over,
Sir, I'm presenting
requiring body
why you are
who has paid the cost of the acquisition, it is on the requiring body to utilize that particular land for other purposes.
Requiring body was never the railway. That is your point, Mr. Dhar.
Defense of India.
Defense of India, you cannot cite Defense of India like a windmill. George
Union
Orwell.
of India. So Union of India is the owner of the defense. As
Union of India may use Defense of India as a windmill. They have a right to. But railway cannot do that. Railway has nothing to do with military per se. Railway is a different wing of the government, different wing of the union. Armed forces are a different wing. We understand that this is required for military purposes. The army is not coming up. And this is under Defense of India rules also. If it was a railway, stretch of railroad, then you could understand. This is a stretch of road. For improvement of road for military purposes. That's for taking the army ammunition, maybe whatever you are saying. But that's the road. Maybe highway authorities, maybe union, some other wing. How does the railway come in at all in the picture? Railway does not have any control over roads unless it's specifically within railway property.
Roads which is approaching towards the station or railway station.
By that logic, every road in India would be under the railways, Mr. Dhar. Either directly or secondarily or tertiarily, every road leads to a railway station. What are you saying?
That was the purpose. I do not have.
You were there when it
other
was
evidence.
done. You were there. That was the purpose. How do we know? You and I can only derive from the records.
Yes.
And Mr. Singh, including Mr. Singh and Mr. Rai.
Those documents have not.
Nothing is there. Precious nothing. Zero.
Regarding
railways.
Regarding railways.
And regarding acquisition also only 0.02, which is admitted by you in your affidavit, as well as borne out by the documents.
Regarding that part, I would like to show that LA case number 2, 2/1, 2/2, 2/3. Kindly come to once again. Take the pen to come to page 372. And
no pen required. We are there. These two pages are open. 193, and we are playing between 193 and
kindly come to page 196 once.
196. Very good.
Yes.
Some variety at last. 196. Yes.
LA case number, my lord, on top, my lord, has got it.
C2246 and the area.
Yes, my lord, I have seen that. My lord, kindly come to
Plot number 2246.02.
Yes, my lord, order on top of the order, LA case number 2 of 1943-44. Now, my lord, kindly cross check with 372. That is LA case number 2/1. But that's what I am trying to, my lord, submit, my lord. Kindly come to now, my lord, kindly come to page 198.
These documents were produced by you.
Yes.
And your affidavit says 0.02 was acquired. Your affidavit says.
I could not lay my hands
regarding. You have to understand this. Regarding 2246, page 196 is the only document you have.
Yes.
Nothing else.
Nothing else.
Regarding the other acquisition process, that
for section 4.6, I'm given a go by.
So let us forget that. Only
Yes.
defense of India.
Only defense of. I am only focusing
Defense
on
of
that.
India rules, page 372. Regarding compensation payment, their plot is not included. Page 372, volume 3.
Difficulty is this form 13 is only in respect of.
It was
LA
your
case
onus
number-
to show, your and their onus to show, not their, the petitioners. You say it's acquired, they don't say, they say it's our plot.
No, my lord, kindly come to page 198. আরে বাবা এই জায়গাগুলো তো আমাকে দেখাতে দেবে।
Arithmetical progression aids. Yes.
My lord, on top, my lord, will find
2.
LA case number 2. Now, my lord, kindly turn to the next page.
Yes.
198A. 18th April 51, my lord, third list of dates. Details order passed in subcase number 2/1 to 2/5, 44. My lord has got it.
We don't know, we cannot assume anything. Either you or the railways have to show us something regarding 2242 having been acquired in its totality 11 decimals. Yes, we find from page this 196 that 2 decimals basically was taken by. You identify, demarcate that 2 decimal, which 2 decimal was taken by you. Let them have the rest of it. And how does the railway come in at all in the picture? Military purposes,
My
railway.
lord, we have stated in our
Railway does civilian work also. You become the army, an army man when you ride the railway, ride a railway.
This question, my lord, perhaps Union of India would be, my lord, because
you have not shown anything to show that this was done for the railways. Railway is a different entity, different autonomous unit of the government. You have to understand this. Railway has civilian functions, railway has military functions, several other functions. In fact, railway does not directly have any military function. The military uses the railways, civilians use the railways. If acquired for military purposes, a road is acquired for military purposes. Therefore, the highway authorities or whoever is in charge of the road, the PWD, whoever, at that point of time, you don't know who is in charge. That body should be responsible.
I bow down. The departmental transfers, if at all had taken amongst the department in Union of India, my lord, that information is not available with the state.
Information is not available, they are entitled to get it.
Perhaps in their affidavit they have disclosed. that how railway got the
My
property.
lord, kindly see page 232. My lord, it shows Southeastern Railway, the owner, my lord. It is the document, my lord, and we have stated in our affidavit, my lord, at page 204. May I place that, my lord? It has revealed from the records that total 33.37 acres of land in 158 numbers of plot from Moja Dulia, JL number 35 of block Sakrail wide ledger number 9175 have already been transferred by the state authorities in the name of Southeastern Railway, including the petitioner's claimed CS RS plot number 2246 corresponding to LR plot number 2278 in full. But the demarcation of all the concerned railway lands from the aforesaid Moza is still awaiting till date. After several letters communicated to the state authorities by the railway authorities, copy of the concerned page from ledger number 9175 with the LR plot number 2278 is annexed herewith and marked with letter R4, which I have showed with your lordship, my lord. It is further revealed from the previous record that any acquisition process of land for railway always been in rectangular square by shape in normal procedure. My lord, this is just to explain. Thereafter, my lord, under D1, one statement showing the surrounding acquired CS Dag number of Dag 2246 JL 35 Moza Dulia Sakrel Howrah with all concerned gadget notification under Section 6 of Land Acquisition Act 1984 and the copies of specimen gadget notification showing the actual norms of any transfer of the government land for any cancellation, relinquishment and modification, erratum, etc. as published through various gadget notification with type copies including one enlarged portion of Moza map of Dulia with the concerned RS plot number 2246 of Dulia. In the aforementioned document also includes one erratum as published through gadget notification dated 6/12/1963 against the previous gadget notification number 17004 LA dated 16/10/1961 for the self-same Moja of Dulia were also handed over to the petitioner during hearing on 28/4/2025 and thereafter issued 1 minutes dated 28/4/2025 for the same. But the petitioner not annexed those related documents in the instant writ petition being number so-and-so, but only annexed the minutes dated 28/4/2025 in the petition as annexure P17 at page number 181. This type of arbitral action so-and-so. My lord, thereafter E, that the Special Land Acquisition Officer General Howrah Wide Memo number 1040 LAG dated 2/5/25 has intimated to this railway that the CS plot number 2246 of Moja Dulia, post Sakrel JL number 35 of District Howrah was already acquired by LA case number 2 of 1943-44 by provincial government in pursuance of Rule 75A2 of the Defense of India Rule through the Calcutta Gazette notification published on 13th May 1943. Copies of the state government
memo.
memo.
The Gazette notification, Mr. Singh, get your order.
My lord, then kindly.
And you have produced 232. Please come to 232. You relied on 232.
232, my lord.
Where is plot 2246 mentioned?
R6. My lord, 236, my lord. There's one document which shows the CS Dag number 246, 247 as blank.
That should be sufficient. That is your answer.
No, my lord. My lord, actually,
all the other plots, Gazette notification number is given 2246, bold letter blank. So use your respective colors.
My lord, in the gadget notification, the number was there, my lord. I'll show your lordship, my lord. 2246. It eligible নয় ও আমাদের ওই কপিতে ছিল 2246. In the notification, my lord, the number was well there, my lord, 2246. And we have showed before the writ court also, my lord.
Shows that
দেখো না,
only one document was produced, 196, where we find the plot number 2246 mentioned. 196, there is a mention of plot number 2246.
My lord, I'll show your lordship. 2246 is there. It is in state's report, my lord. My lord, kindly comes to page 133.
2246. Sorry, page
2246. My lord, page 133, my lord.
Yes.
Appellant have showed this, my lord. Page 133, schedule B. Well below the page 133, my lord, under schedule B. Left hand side, my lord. Your lordships have got it.
Precisely, this was section 4 notification. Under the LA Act, section 4 is the initial notification. Then there has to be followed up a follow-up declaration under section 6.
My lord, that
only
is
after section 6, you know that.
I appreciate, my lord, what your lordship is saying.
The
This is
acquisition
what
process commences
my
after
senior
that.
was showing your lordship, my
He
lord.
has not relied on that.
With regard to the case numbers, my lord, all these was allotted a case number, my lord. And under those case numbers, they were paid, my lord.
Just because there is a confusion, we cannot say that this plot was acquired. If somebody asserts a positive assertion, he or she or it has to provide it, has to prove it. It's you and the state who are asserting that this plot has been acquired. It's not the petitioner who is saying it or the appellant who is saying it. They say it's my plot and I want a mutation of that. You sought for a mutation initially. Or what?
No, they issued my stop work notice. I have challenged.
That was the genesis of this.
Yes.
So you issued a stop work notice on the basis of maybe a mistake, maybe correct, we don't know. If you issue a stop work notice and they say no, this was never acquired for the railways or by the state, then it's the railways or it's the state or you who have to show that no, this was acquired. The matter came up before the writ court. Writ court directed your officer to ascertain it on good faith that your officer will ascertain on the basis of documents. Now, what does your officer do, which is challenged in the writ petition? He say or she, whoever says that they have failed to produce any document. You have said that from your records it's evident, but nothing is placed, nothing is considered even. When we are considering before the writ court, we are finding that there is nothing. 2246, there is nothing.
My lord, we have come to know about that this land belongs to us, my lord, from the state authority. That is why we are dependent upon the state authority to give the, because
You
land.
sue the state authorities subject to the election. To the state authority. Ask for damages from.
My lord, due to public interest
One
litigation.
whistleblower came before this court by filing a public interest litigation, and my lord,
Everybody nowadays blows a whistle. What was the whistle about?
My lord, that this particular land is the railway is the owner, and under Defense of India Act, it was previously requisitioned and subsequently acquired. And my lord, that public interest litigation was moved.
He tried to intervene. That was rejected in this matter.
In this matter, he tried to intervene.
It is rejected.
It was rejected.
And my lord, that too, my lord, that order passed to consider the representation, nothing more than that.
We are closing arguments on this. We pass judgment later. We'll have to look into the documents if we miss out something which is in your favor.
All I can say, my lord, I can show that LA case number 2/5, my lord, till 2/5, I could not, my lord, give the details of the award.
No name of the petitioner.
So relevant pages we are required to look at whatever has been cited by you. Apparently is page 196 you have relied on.
Yes.
332 has been relied on by somebody. 266. Not 332. And also this page 8082 you have relied on. Is 72.
372.
Yes. Mr. Singh, you relied on
my affidavit, my lord. And the annexures, my
But
lord.
that was their section 4 also.
My lord.
So those are covered by page 80, 82. Okay.
Yes.
We have tagged all the pages, so
Grateful.
right now we don't want to pass the judgment because it will take some time and we may miss out on something. So we want to go through the documents and we'll pass it.
My lord, this is reserved, my lord.
Reserved. We are passing on.
Grateful.
Heard learned counsel for the parties, first of the affidavits in opposition and reply filed respectively by the state and the appellant today be kept on record. First up, hearing is concluded and the matter is reserved for judgment.
Certified copy of the law.
I'm grateful to my lord.
Don't forget Mr. Rai. Yes.
Lord, I had reliance upon Mr. Singh. Lord, probably Lord, he tried to Lord, possibly he tried.
No, he did his best, Mr. Rai.
Yes, yes.
You are in good hands.
Yes.
Grateful, my lord.
I'm extremely grateful to him. Extremely.
Thank you very much, Mr. Yes. Next. Left.
May please, Dr. Miller. Well, sitting, well, may I ask for not today? I've got a flight to catch. That's all.
When?
To Araku Valley.
No, not when. When? We are not.
When next, well, I'm ready, fully ready.
When is your flight?
5:30 p.m. 5:30. Indigo.
Mr. Mithu, we have been consistently putting matters out of the list for adjournment. So somebody has. You can start.
I can say, well, I tell you, it's a matter of Urban Land Ceiling Act. Now, question is, we are entitled to claim exclusions on this HUF property. First was that 500 meters each, four co-personers. That point was argued. State also argued that point against us, and learned judge held in our favor by this judgment. Other 3 points for the exclusions were argued by us. That's a final judgment recorded. State did not give any reply to those arguments. But in the judgment and order portion, I find the learned judge had directed, set aside the order of assessment, that remanded the matter to the department and saying that you allow this 500 meters each under section 47. But other 3 points, grounds of exclusion, which are argued and to which there is no reply of the state government, the order is silent. That's why you have to prefer an appeal.
Well, Mr. Mithu, we are recording that you have commenced argument but could not be concluded today. We're not making it part of it. So that's the language we've evolved.
Possibly somebody else is also online. Mr. Mukherjee, I see, is online for the same matter.
Mr. Mukherjee, Mr. Mithu has a flight to catch. So what is your take on that?
I'm no objection. I can't speak. I have some difficulties.
So, Mr.
Finished with a short time.
Mr. Mukherjee and Mr. Mithu, we are keeping it next Thursday. Thursdays we take up these matters. This will be pretty up on the list because we have disposed of the previous matters.
He written his position, my lord, on Thursday.
No, it may go up.
Go up.
Because 2 matters we have already heard.
Why?
Although the matter is taken up for hearing, in view of personal difficulty of senior counsel appearing for the appellant, matter is adjourned for the day, to be listed next under the same heading on April 9, 2026.
Well, no, bless you. I would have the pleasure of finishing.
No, if you are there, Mr. Mukherjee is there, we are sure that you will finish it quickly. Yes.
We arrange the holidays. That's right. Oh, bless. Yes.
No difficulties.
My lord, this is our my lord.
Yes, Mr. Adhikar.
My lord, continue.
Mr. Adhikari, only one thing. You have a resolution today, the bar.
Therefore, my lord, because we are always under the.
You are appealing for the state.
Oh, Lordship, I am for the private respondent, Miller.
If all the parties are not there,
yes,
we can take up the. We don't have any binding. We are not bound by the.
No, my lord, we are.
Your
Resolution must have to be respected.
State is there. Start.
Yes, my lord.
So no difficult. Private respondent is there, state is there.
Yes, ma'am.
And Mr. Odhikar is there.
My lord, our case, my lord, is your lordships. My lord, there was argument on that. Actually, it's a sand mining lease, my lord.
Oh.
My lord, in Subarnarekha River, my lord, there was an, my lord, auction bid, and my lord, tender was called for, and my lord, we were the successful bidder. And my lord, by paying near about rupees 2 crore and 22 lakhs rupees, my lord, at a time, my lord, means using that means that very particular, my lord, the accumulating the huge amount from the market, my lord. I have, my lord, complied everything. And in the year 2017, my lord, there was a registered, my lord, deed of lease by and between the governmental authority and myself, my lord. And my lord, it was for continuous period of 5 years. And my lord, term of the lease are there. And there are stipulations.
Minor minerals এক্সগুলো আছে ওইগুলো বইগুলো লাগবে দুটো আছে আগেরটা পরেরটা ওইগুলো একটু দিন please continue sir.
My lord, there were the stipulations that, my lord, I am an outsider. And my lord, that
outsider means
that the means at the particular zone of operation, my lord, that the I am not the resident there. I am residing somewhere else. With all manpower, I am to work it, and I was working smoothly for near about 1 year. And my lord, there was no disturbance. There was carrying order. My lord, the rule is, my lord, I will excavate the sand by my own man and machineries. And my lord, that will be until and unless there is carrying order which will be issued by the appropriate statutory authorities. That means the state authorities, my lord. It is not possible, at least that to transport this, because my lord, then it will be, my lord, it will be means mafia activities. My lord, to make it everything legal, my lord, there is another parties, that means to issue carrying order. And carrying order is the obligation on the part of the statutory authorities. There is no doubt about it. And as per the lease agreement and as per the registered deed of lease, it is there. Therefore, my lord, that it was incumbent upon us to pay the entire amount, to have the lease registered, to have operational material and also men there, and to excavate it. And my lord, thereafter, my lord, they are to issue the carrying order. And if they will not issue the carrying order, then every, my lord, that it will be frustrated and everything will be there. And if there will rain, then everything will be flooded. My lord, there will be, my lord, that the stealing, and there will be, my lord, the theft or robbery or whatever maybe that's such. Then, my lord, that it is an integral part of the entire operational system is, my lord, the carrying order. Therefore, when there was carrying order is to be issued by them, then, my lord, at their sweet will, caprice and choice, the concerned state authorities, my lord, they were trying to create problem. And my lord, at the behest of some, my lord, whatever maybe it happens everywhere, wherever the money, there are a problem. Ortho anarthir mool, that we have learned from our boyhood, my lord. Therefore, that was the, my lord, therefore there was mafia, etc. Now, my lord, there is to be very frank, my lord, there is a, my lord, relationship between all these, my lord, the ward practitioners with the governmental machinery, some stuff, my lord. It is the sanctity and wisdom. It varies from man to man, person to person. Institutionally, my lord, the sacrosanct institution and sanctity, wisdom, there is no doubt. But, my lord, that is those who are working under the institution, if they will not do it, then, my lord, there are some, my lord, rules, norms, practice, and procedure. And the obligations, it is the duty on the part of the superior authority only to see that whether these are done in perfectly or not. My lord, after, my lord, that the completion of 1 year, when, my lord, it is found that, well, he is developing in this way, they were not seen that, well, that I have already spent from the market, I have collected rupees 2 crore and 22 lakhs rupees and I have given it. Government is also, these machineries, they are not cooperating with me. And they did not issue the carrying order on these pleas or that pleas. My lord, in the supplementary affidavit, my lord, with leave of this honorable court and with giving copy to them, and also they have given reply to it, we have specifically stated, my lord, one after another. That means that the series of representations were made that issue the carrying order, like before. But my lord, they remained silent. Silence, my lord, without any adjudication of any representation, my lord. It is not a bona fide exercise. It is well settled by the Honorable Supreme Court in series of judgment. And my lord, there is touch of malafide. Therefore, my lord, when these representations were made, my lord, to make very short, my lord, the obligation on their part is to issue carrying order. Our part is, that means to ask for that on the basis of our representation, that well, that we are giving it. But my lord, they remained tight over the issue, they did not issue it. Rather, my lord, in the air, it was shown, that means that there was something, you have done something privately, therefore we are not doing. We were asking every time that give it in writing. Whatever, my lord, that we are under the sun, under a civilized society, and my lord, there is a civil rules, and my lord, custom, and also all these proceedings are there, and in my lord, that we are to abide by it, and it's the citizen's duty as well as the duty of all these statutory authorities. My lord, but my lord, they did not pay any heed to all our these carrying orders. My lord, to what these
25 July.
On my lord,
After that,
my lord, the whatever happened, what happened, my lord, ultimately, your lordship will find in this way the time was over. For no reason, for no, my lord, that the I cannot be penalized. The incumbent, the citizen, the person who has come forward for doing some, my lord, work as per the registered lease deed, as per the, my lord, that the very particular tender, my lord, that we were not allowed to do any work, not to issue the carrying order. Means they were not issuing. In this way,
reject our
when,
application on 20.
and my lord, that when
in this matter, written notes of arguments had been filed already.
my lord, at that point of, at that point of time, your lordship asked for it. That means that to extend the means interim means the order of injunction, it is necessary. Therefore, file it. Therefore, immediately
So
we
you
have
follow
filed
the
it.
broad outlines of these.
My lord, that the question remains, my lord, what happens, my lord?
You just
The
point out to the
injunction
relevant points
order,
and
my lord, the injunction order is up to 2 days, up to the date of hearing. My lord, that on the
No,
previous
we are hearing
date,
the matter.
therefore, my lord, that
Already your written notes are on
written notes of argument
Will
for the limited purpose at that point of time.
Is any
it
other
was
point
given-
involved apart from these?
Yes, my lord, that the other points are
Purpose
involved
may
there.
be limited,
It
but
was
the points
purpose.
remain the same.
No, my lord, that there are some more, because that it a detailed version, my lord, at that point of time, it was incumbent upon the upon my lord, that they asked at least that to satisfy the honorable court, at least for a stay, because on the, that means that it is necessary. Then on that day, my lord, within short notice of 24 hours or 48 hours, we have given it, and my lord, that your lordships are pleased that that it is a fit case at it to grant
So you
a stay.
outline your main
Now,
points.
my
Mr.
lord,
Supreme
your
Court.
lordship,
Outline your main points. We'll just.
Reject our application.
my lord, your lordship will kindly see on 25/7/22. My lord, it is. Respondent number 6 rejected applicant's application for extension of lease, alleging violation of lease conditions. And my lord, that when the lease period expired on 31/7/22, my lord, beforehand only, my lord, only on 25/7/22, they were saying that no, there you have violated the lease conditions. Therefore, my lord, after elapse of so many years, my lord, from 18, my lord, to 22 years, when there were a series of, my lord, that the representations were made for issuing carrying order one after another, which we have completely, my lord, that because after the, my lord, submission of these written note of arguments, my lord, when there was full-fledged argument, my lord, that it was attempted, then, my lord, that beforehand, my lord, immediately thereafter, we have collected all these things, and as per your lordship's wishes, that that so that everything will be, my lord, come as a clear picture, and a transparency of both sides will be, my lord, that will be seen or will be visible by the honorable court, and the honorable court will come to a definite conclusion. Thereafter, my lord, there's supplementary evidence. My lord, therefore, my lord, the development is, that means that a supplementary evidence with the leave of the honorable court and with copy to the other side, and they have replied to it. My lord, it is there. Therefore, my lord, now it has been extended. Now we have to say, my lord, but we have to start from there. On, my lord, the now, my lord, the lease period, my lord, kindly. Kindly take note of it, my lord, that the on 25/7/22, they for the first time they have disclosed. That means just when on the verge of it, that means that on and before 6 days. That means of expiry, 6 days of 6 days before the expiry of lease period expiry. That means that yes, your application is rejected for extension of lease, alleging violation of lease condition. In the meantime, what happened, my lord?
Your lease deed was to expire on 31st of July 22.
31st of July 2022.
And they gave this notice on 26th.
25th July 2022. They have rejected. And my lord, there was also
Rejected what? Your
rejected my application
for carrying order.
Extension of lease for carrying order for extension of lease. My
For
lord,
carrying order or for extension of lease?
For application for carrying order. My lord, application for carrying order. Actually, no extension at that point of time, my lord. At that point, actually, we are harping on it. That means that issue it. But they are saying that, well, no, it is going to be extended and it is not be, and you have violated it. And my lord, that too, my lord, that in that means beforehand, we have come, my lord, that on 2 rounds, my lord, that the Honorable High Court has passed order, my lord, in our favor. We have proceeded before the Honorable Single Judge, and the Honorable Single Judge was pleased. First of all, my lord, the private respondent proceeded before the Honorable Court. And my lord, that the Honorable Court, my lord, single bench.
What the order they had applied for the division of commission, they had applied for the single judge. That is, they had not added us party. They proceed singly. Then they obtained the order in our back. They also suppressed, my lord, even though they had filed one PIL before the divisions bench, and their order also they had not challenged. The divisions bench also said that the carrying order should not be issued and it is a purely motivated one. That is also they had suppressed. That time also they had not party. When they had filed an appeal before the division of commissioner, that time they had incorporated as a party, not at the time of
and one.
And
of the writ petition.
they totally obtained
They're not to issue a carry order to them.
No, my lord.
To themselves.
In my ability, give me এক মিনিট দাঁড়াও না, তোমাকে কিছু বলতে হবে না। My lord, in my ability in opposition, my lord,
Yes,
they had suppressed many things.
দাঁড়াও না একটু, কেন ওটা তো আমাদের ব্যাপার।
My lord, your lordship will kindly see that what is fraud and where is fraud and where the started. That means that, well, why fraud?
Affidavit of state, yes.
Yes, my lord. If your lordship, first, my lord, paragraph 9. Page 3. My lord, lease deed was executed between the governor and the Harishchandra Bera,
Yes.
and the same was registered and Ato, and district sub-registered. And possession was handed over to the block land development Sakrail 1st September 2017. Now, my lord, paragraph 10.
Why?
On 30th September 2019, a letter was received by additional district magistrate and district land and land development Jharkhand in the ADM Jharkhand Harishchandra Bera requesting to stop issuing carrying order against his name, my lord. Photocopy is, my lord. I am giving the photocopy.
Page 10.
Yes, my lord. Now, my lord, if your lordship will come next, my lord, again 11, my lord.
He is jumping.
Yes,
Mr. Day is jumping from one point to another point. But is he means very fair to speak before the Honorable Court that why I have stopped it, where I stopped it? Yes, no, yes, you tell. I have given answer.
My lord, next, my lord, if your lordship will come, paragraph 11.
Supplementary.
Reiterates that I have issued earlier due to my disabled circumstance.
My lord, next, my lord.
So now he wants reissue of carrying order.
Now, my lord, next, my lord, reject ADM LR Jharkhand to reject the authorization order in favor of Rajkumar Sinha, my lord, in Ato. On 6th November 2019, my lord, he filed an application ADM LR Jharkhand to reject his authorization letter issued in favor of Rajkumar Sinha.
That is your client.
No. They authorized to some third party without the approval of the authority.
Now, my lord, I am coming that
you are not there.
Violation.
No.
Now, my lord, on that 13th, my lord, a letter has been received on Ato requesting ADML not to issue carrying order. Again, my lord, to any person for Ato, sitting Ato. Now, paragraph 14, my lord. A letter has been issued, received from Subroto Das on behalf of his clients, HON'BLE Sina and 3 others, which reveals that the lessee Sri Harish Chandra Bera has entered into a partnership agreement with the clients, the learned advocate, through a registered partnership deed being number Ato, registered and executed before the additional district sub-register Sodor Paschim Medinipur. The letter also reveals that a title suit being number Ato was filed in civil court against the lessee as he is not following the terms and conditions. Now, my lord, paragraph 15 is very important. Now, my lord, we have started proceeding according to the citing violation of Rule 22 of the West Bengal Minor and Minerals Rules and the terms and conditions as mentioned in clause 14 and 15, part 7, read with clause 2 of part 9 of the lease deed in respect of the said mining block. A so-called letter was issued to the lessee by the district magistrate chairman Atu Jhargram by name number Atu. Now, my lord, lessee has provided so-called by Ato. Hearing was conducted and Ato, HON'BLE Singh and others moved before the single bench, Honorable High Court, Calcutta, and filed a writ petition being number Ato against that statement Ato. And what that is, my lord, that is the, my lord, what is 22? If your lordship will see what is 22. West Bengal Minor Minerals.
Yes, no, we have.
এবার ওইটা বের কর, ওইটা বের কর, ওই 15, 14 and 15 of the lease deed.
Rules.
My lord, that is 22, my lord.
Rule.
West Bengal Minor Mineral Concession Rules, my lord.
This is Rule 22.
Yes, my lord.
Right.
The lessee shall not, without the previous consent in writing of the state government or the lease granting authority, assign mortgage or in any other manner transfer the mining lease to or any right, title or interest there.
But they had alleged this partnership deed.
Yes, my lord. And
did
my
they
lord,
produce the deed also?
Yes, my lord.
So what did you do?
My lord,
You stopped.
After that, my lord, we cancel the now, my lord, if your lordship will see the agreement also, my lord, 14 and 15, clause 14 and 15 there. Page 41, my lord, if your lordship will see.
Of their application.
Of their
We have produced lease deed. And who has cancelled and whether it has at all been cancelled or not.
Yes.
My lord, if your lordship will 14 and 15, my lord.
Page 41.
Page 41, my lord. The lessee shall not, without the
Very
previous
clear.
consent in writing of the state government, assign mortgage or in any other manner, transfer the mining lease or any right, title or interest thereof. Enter into or make an agreement, arrangement, contract or understanding whereby the lessee will.
We have seen both 14 and 15.
Yes.
They cannot enter into an arrangement or cannot be controlled by any trust
Yes, my lord.
firm.
After that, my lord, so my lord, is not only he, my lord, violates the provisions of the West Bengal Minor Minerals Concession Rules, but my lord, there violates the agreement also. That is the 14 and 15 of the. That is, I am stating very clearly, my lord. That is my lord, my ABTBT in opposition, paragraph 9 to paragraph is very important, my lord. That is, I have 21. Everything I am stated in my ABTBT in opposition. So, my lord, he is not entitled to. He.
You have terminated that.
Yes, my lord. No.
Now, what was
Termination. That is the entire. Let them show.
Time was.
Let them show. When they are saying let them show, your lordship has rightly pointed out.
So, yes.
My lord, his period is, my lord, 9. If your lordship will see, paragraph 9, 9 is period. His period, my lord, he took the possession on 1st September 2017.
So up
for
to
5 years.
That Mr. Odhikari himself says that up to 31st of July.
That is automatically, there is very.
By a flux of time.
Yes, my lord. For the 5 years, we can't.
Lordship, that is the for private respondent.
No, we are not hearing Mr. Odhikari in the midst of it. Yes.
My lord.
Civil suit, can.
My lord, kindly have a look. My lord, whatever may be, a civil suit was preferred by Mr. Singla's part, Mr. Singla. I think that is
Private
Amol
Singho.
and Amol Singh.
Not Singla,
Private
Singho.
Singho.
Better than Singla.
Page 82. Page 82, my lord,
Can
that
one.
will
Can
can of the can one, if your lordship will kindly see.
Yes.
Therefore, my lord, there is no matter by and between the government and etc. etc. Government's restriction will be imposed when there is something one where it will be affected. And government will be a mute spectator when there is a private thing is going on and it is.
There's a bar in your lease deed and Rule 22. So how to
No,
overcome that?
but it is to be interpreted in this way because that the legislative intent is that means that if it is one something which is illegal or legal, valid or invalid, this is to be seen. Whether this is a foul play on the part of the government in unholy nexus with some governmental officer or not, that is to be
You
seen.
entered into the partnership. How can there be a foul play by them?
So, because that if your lordship will kindly see, that means if it is the partnership agreement,
You are Horishchandra Bera.
then
You are Mr. Horishchandra Bera.
I am Mr. Horishchandra Bera.
So you should speak the truth.
And I'm to
See the
speak the
partnership deed.
see. First of all, your lordship will kindly see. That means that they have started the other side. That means the private respondent. They have started, my lord, that a civil suit before the Jhargram Civil Court Junior Division, page 83.
Yes.
111.
Page 83. My lord, if your lordship will kindly see,
111.
now thereafter your lordship will kindly see
Footage dismissed.
page number 111. Page number 111. Your lordship will kindly see the suit and the same is dismissed for default 11/12/2023 as there was no merit. In the meantime,
So for default means no merit.
I understand. Dismiss for default does not necessarily mean that it is a, my lord, that we will get advantage of it, but the other side will take advantage of it if in the meantime they will not statutorily, they will restore it. This means that they have invited, that means that they wish to not go. It is called in one sense successful retreat. That means they are retreating, but they are saying some confusion has been left. This is the, my lord, that the private respondent's duty. And they have, my lord, performed their duty in this way and manner. And now, your lordship, this is the vital one, page 112. This is the, my lord.
Private respondent filed the writ.
Now, my lord, the private respondent has proceeded before this honorable court. First. Now, just some time back, some minutes back, the learned advocate has, my lord, told, my lord has made the submission before this honorable division bench. My lord, the highest bench of the state. My lord, highest bench of the jurisdiction. No.
Highest bench is sitting.
No, but on this jurisdiction.
Number one.
On this jurisdiction. On this jurisdiction, your lordship is the, my lord, it has been, my lord, far back. My lord defined, that means that in each way, your lordship is the highest. My lord, that my learned friend of the other side, he has stated that no, we have not proceeded. But my lord, kindly see page number 112.
No, I have not submitted. You just have put the word.
Amol, Singho and others versus the state of West Bengal. My lord, therefore, that very private party, my lord, he proceeded before the honorable.
This was your partner in the partnership.
Not I'm partner, I do not know even. My signature has also been fraudulently taken. But my lord, they are the mafia of the local area, my lord, in some way. My lord, some officers, they are involved, my lord, police involved. All knows, my lord, what is going on behind the everything, my lord. My lord, your lordship kindly see. Therefore, your lordship kindly see March something and 2000. Now, your lordship kindly see the order. Private respondent was entrusted to participate in the e-auction on behalf of the partnership firm by the petitioner, who actually put in funds for the same.
And this is in which page?
At page 112, my lord. Page 112.
112.
Second paragraph.
Can 1.
In can 1, my lord, your lordship, can you see? Can 1.
Can 1, 112.
Annexure H.
Yes, my lord. It is Annexure H, my lord.
Annexure H, yes.
Page 112, my lord.
Yes, you're reading.
I'll start, my lord, that the third paragraph. The contention of the petitioner is that
yes.
Despite a deed of partnership existing between the petitioners and the private respondent, a lease for the purpose of settlement of sand quarry was issued in favor of the private respondent by the state respondents through the private respondent.
Here we are private respondent.
Though though the private respondent was entrusted to participate in the e-auction on behalf of the partnership firm by the petitioners. Therefore, my lord, such a, my lord, that the bold false allegation has been put forth before the honorable court.
Okay.
There was none. Only I, Harishchandra Bera, I participated in my name, and they were saying that in the partnership firm there was a partnership, and on behalf of that very particular partnership, Harishchandra Bera, petitioner, has proceeded in auction, and we have paid the entire amount or a substantial sum of the entire. It is such. But now your lordship kindly see, the petitioner submits that they made an application before the state respondent, the petitioner, that means that the private respondent party, for grant of query permit in the name of the partnership firm being Ma Kali Partnership, as the said permit was procured by the private respondent fraudulently. Their case is that I have procured a civil suit praying for a decree of permanent injunction was filed by the petitioners, and the learned court, by an order dated 7th November 2019, refused the prayer for an interim injunction. They proceeded, and it has been recorded by the honorable, by the honorable High Court, by the Reed Court, my lord. There it is further submitted that the mining has been closed down at present. And it is not known at whose instance such closure has taken place. It is vital at whose instance such closure is taken place. Therefore, definitely, my lord, we come to this reasonable conclusion, means at the instance of the government, who is not a party there, who has nothing to do. They have proceeded there. They are saying, and the court is also asking, the Reed Court is also asking, at whose instance it has been closed. The petitioners prayed for issuance of a writ of mandamus against the state respondents for withdrawal of the closure order and grant of the lease in the name of the partnership business. Grant of the lease. My lord, how it is possible? Such a funny prayer. Business in place of the private respondent. When they have failed there, then the private respondent came. And the state is also encouraging. Learned counsel appearing for the private respondent has taken this court to the permit issued in favor of this respondent on 31st March 2017. My lord, it is our case. Learned counsel has further referred to the deed of partnership dated 31st August 2018, that is post grant of lease in favor of the private respondent. According to the learned counsel, the private respondent participated in the e-auction and was declared the highest bidder therein prior to formation of the alleged partnership. And the said partnership did never came into operation at all.
Next paragraph.
Referring to paragraph 4 of the writ petition, learned counsel for the state respondents has submitted that it is the admitted position that prior to the partnership agreement, the private respondent participated in the e-auction for said mining, for sand mining, and was declared as the highest bidder therein. I have considered the submissions made on behalf of the parties. It appears from the deed of partnership as well as the permit granted in favor of the private respondent that the permit was granted prior to execution of the deed of partnership, such fact being admitted by the petitioners in paragraph 4 of the writ petition. The claim of the writ petitioners that the private respondent had no fund to participate in the e-auction and was provided with such fund by the petitioners on an understanding that the permit would be issued in favor of the partnership firm calls for adjudication by the appropriate forum and is beyond the purview of the present writ petition. No, my lord, they lost the chance because that the civil court is the appropriate forum. They are not even there after the order, though there was the specific direction that this court is means that cannot do it and go to appropriate from that is civil court, and by that time, my lord, that they have not proceeded. Now, the dispute in this petition is primarily between the petitioners and the private respondent, and the state respondents have little role to play. My lord, Mr. Day, when he is submitted that while I am the be all and end all of it, then therefore that when in their presence that means in that very particular private disputes between the parties, whether it is according to legal or not, my lord, it is quite a fraudulent one, and my lord that not even my lord that it was registered in the appropriate authority, register of my lord that it is not. If your lordship will kindly say, then it is my lord, it is so ridiculous, my lord. What I will say, and my lord, the honorable court already it has been decided by the honorable court. After thorough examination, therefore, my lord, your lordship kindly see, therefore, that the state respondents have little role to play herein, as the query permit was issued much prior to the deed of partnership coming into existence. What else remained? Mr. Day, if will say that well, this is such, this is such, this is such, whether he can re-agitate, whether he will not means that it means Mr. Day, a senior advocate, my lord, we have got great respect for him in another circle. But in this circle, my lord, I must firmly say, my lord, if this type of submission that this is such, when the court has already decided, and then they proceeded in the division bench also, division bench negated that they, well, it is such, and the state had got very important role there. Because in every read, the state has role. Therefore, when state has got two bounces against it, therefore, my lord, that then whether they can come again to this to confuse the honorable court, this forum, that I am saying, that I am asking to myself, and asking the conscience of my learned friend, that it is such, we are not to confuse the honorable court, because ultimately we have to answer before the, my lord, the Almighty. That is the core concept, and therefore I am also. Now, my lord, that the dispute in this again is primarily between the petitioner, the private respondent, and the state respondent have little role to play herein, as the query permit was issued much prior to the deed of partnership coming into existence. The private respondent participated in e-auction in his individual capacity, means I, Misal,
And watch.
and was granted the permit in such capacity. The partnership deed was executed and registered after more than a year of issuance of the query permit. Clause 9.3 of the notice inviting e-auction is relied upon by the petitioners. The said clause demonstrates that the date of commencement of the period for which the mining lease deed is executed shall be the date on which is duly executed mining lease is registered, in which a duly registered mining lease is registered. It deals with the date of commencement of the period of the lease and has no bearing with the contention of the petitioner hearing. In view of the same, the writ petition is devoid of any merit and is liable to be dismissed. Accordingly, this is dismissed. Therefore,
against this, the private respondent go to the.
now, my lord, if your lordship kindly see, then against this very particular order, they took the chance before the division bench. And my lord, your lordship will kindly see same party, Sri Amol Singho and others versus Bodhisattva. Now, my lord, 2/5/2022, page 18, annexure I. My lord, kindly have a look, my lord. There, your lordship will kindly see. The appellants approached the learned single judge with the grievance that the private respondent has obtained the mining lease in question in his individual name, when the agreement between the writ petitioners and the private respondent was that the mining lease will be obtained in the name of the partnership firm of which the writ petitioners and the private respondent are said to be parties. Are said to be partners. The writ petitioners urged that they financed the entire process. Now you are also kindly see, my lord, that the honorable court is to see. That means that how transparent the case of either side is. And if your lordship will find it, that means that if a man comes with unclean hand, then my lord, the honorable court will not allow him to make further submission. My lord, the state has also, my lord, the duty, because state is, my lord, that they doing not only, my lord, in these or such cases, as my lord, a co-adjudicator, my lord, they will do. And my lord, that otherwise there will be avalanche of cases and the court will be burdened by it, and then it is. Therefore, the state has got some role where they are to do it as per the, my lord, that the rules, norms, practice, and procedure, and with all sanctity and wisdom. My lord, I am asking to in this way, my lord, that whether Mr. Day has seen all this or not. Therefore, the writ petition urges that they finance the entire process. It was the case. The private respondent, by colluding with the state, my lord, therefore, it is not my submission. The private respondent, by colluding with the state. My lord, this is the most important thing.
State of officers.
My lord, your lordship kindly see, officials has managed to obtain the mining lease in his individual name. Therefore, my lord, that a pollution has been, my lord, that created by them. State must have to take it what is what. My lord, that if this is such, and my lord, it has been properly recorded. The learned single judge heard all the parties at length. It was found by the learned judge that the private respondent participated in the e-tender in his individual capacity, and on the relevant date, the partnership had not even been constituted. Therefore, so far the carrying order is concerned, how it is relevant to it. I am saying it. That means that we cannot mean by making a camouflage situation. My lord, that to mingle in this way and manner, and to, my lord, to create doubt, confusion, and, my lord, convincing and confusing. That is to be seen. And, my lord, whether we are on the fair stand or not and paying huge amount, my lord, that whether in a stage, my lord, that how we have been ruined, that is to be seen by the honorable court, my lord. The mining lease was naturally granted in the name of the private respondent upon he becoming the highest tenderer. Before us, learned advocate for the appellants vehemently argues that there has been serious collusion between the concerned state officers and the private respondent. The private respondent has taken crores of rupees from the appellant. My lord, it is a serious allegation against what state has done. My lord, we find that the appellants have approached the civil forum. This is the clear finding of the Honorable Division Bench and made it very much clear so that there will be complete end of the entire episode. But, my lord, again we are coming, and in this way, my lord, that we are going to ruin this. We find that the appellant have approached the civil forum by filing a suit being title suit number 160 of 2019 in the Court of Civil Judge Senior Division, Jharkhand. There, the petitioner's prayer for ad interim injunction has been refused by the learned judge by an order dated November 7, 2019. The state has been made a party defendant in that suit. It appears that being unsuccessful in obtaining a favorable order at the interim stage from the civil court, the writ petitioners appellant are trying their luck before this court. This is to be seen. That means that what is the observation of a division bench? My lord, a collateral bench, my lord. The dispute is essentially between the writ petitioners and the private respondent, which is purely of civil nature. The point of collusion between the state officers and the private respondent also cannot be gone into by the writ court. We do not see any infirmity in the order under appeal. However, any observation made herein will not have any bearing on the hearing of the case pending before the Jharkhand court. So, my lord, that they were given another gate pass to proceed again. With this order, they could have proceeded there, could have done there to have order, and that this is why they have not proceeded. My lord, there is some, that means that some minutely, silently, some do observe, some do something, and, my lord, that the some openly will do. My lord, that whether they are the silent killer or not, that is to be seen. Means they are to frustrate the intermission in this way, and, my lord, that the state, my lord, a role has been imposed upon the state to see. That means that on that very particular time, at least that when there was, my lord, that the honorable division bench, collateral bench, my lord, has come to this definite conclusion. The appeal and the application are accordingly disposed of. All parties shall act on it. Therefore, it is such. If that being the position, my lord. Now, if the very particular submission made by Mr. Day on behalf of the state, at least when we have filed it, whether it is tenable, if your lordship will now kindly take pain to go through, that means in this way, therefore jumping in this way one after another. Why there is suppression? Non-disclosure is also a material fact. Non-disclosure of material fact does necessarily mean suppression of material fact if it is relevant for adjudication of the entire dispute. It is such, if your lordship kindly see, my lord, if, my lord, that when it is such, if my supplementary affidavit will be seen, my lord, if there is here any answer to it, my lord, Mr. Day, being the state's representative, my lord, has not made. You will also kindly see in the page 14, page 14 of the supplementary evidence. Kindly take pain to go through, my lord. The will be, yes. Annexer, yes, my lord. Onwards, my lord. Page 14.
copy
দিয়েছি তোমাদেরকে
না সাপ্লিমেন্টারি এফিডেভিট ওই হ্যাড নট রিসিভড
সব দেওয়া হয়েছে দিয়ে দেওয়া আছে রেকর্ড উইল স্পিক ফর ইটসেলফ তুমি 25/10/2019 apply for reissuing carrying order against the lessee Harish Chandra Bera sir to the ADM DLR Jharkhand. With due respect, have you lordship, my lord, the 25/10/2019, my lord, There will also kindly see. With due respect, I, Horizontal Panel, lessee of such and such, I have applied earlier to stop issuing my carrying order for some disable circumstance. At present, I have solved my earlier problem. There will be this is a problem. The High Court is there. Therefore, there is such state was reluctant to see. That means that a late here be something. Yes, you do, and late means that it was not such. Only now, Mr. Day is showing that the well, this is that they have said that there is no carrying order. But my lord, that the well, 5 years course is a long course. Today I am before your lordship. Tomorrow I may be at the burial ground, or maybe at the crematorium. My lord, it is not such. But my lord, the change of circumstances is, if I am alive, then my lord, again, my lord, I will take my chance on the next Thursday. This is the life. Then my lord, only remains sticked, my lord, on this, that well, on a very narrow, pedantic, people issue, that it is such.
If you argue like this, Mr. Adhikari, you may not live till next. You have to cut short.
My lord, what I am to say? Then my lord, you kindly see, my lord.
Otherwise, it will be
My lord,
adjourned, I may die.
My lord, adjourned sine die means after my death may be taken up, because my client has already been dead, because now yes, my lord. Now, my lord, that the rain water is already there, and Subarna Rekha, my lord, is under flood very soon. Now, my lord, several my lord, kindly see page 15, my lord. You will also kindly see page 17, page 17. Now you will also kindly see 11, 19. The same carrying order for issuing of the carrying order 20, 21 for issuance of the my lord subject.
Yes, you refer to this.
Yes, you will also kindly see 11 and 19. Whether at that relevant point of time they have taken any, my lord, I am asking, my lord, at that point of time. That means that before going to read court, my lord, what state has taken all these?
Up to page 34.
My lord, up to page 34, it is there, my representation. You will also kindly see 15, 11, 2019. Therefore, my lord, you will also kindly see what is wrong on my part.
Then we file the petition.
Then, my lord, that if, my lord, that when it was
appellant filed the petition.
Now, my lord, if your lordship will kindly see, therefore, my simple prayer was to issue the carrying order. Carrying order is a different subject. Even when the matter, my lord, that was before the Honorable High Court, and my lord, that before the my lord, before the single bench and before the division bench, my lord, state was, my lord, whether watching, my lord, that what is going on, and will take chance it, and one in the fine morning, my lord, that when it was going to be terminated. Then, my lord, then they issued it on my representation that, well, what representation you have given? Is it a termination? Your lordship has rightly pointed out that the termination must have to be either termination or give representations means answer. Therefore, my lord, what does it mean? Does it not mean that means that there is some lack of bona fide on the part of the state authorities? My lord, if your lordship will say that no, still there is not such, I will go it. That, my lord, I am to say. Your lordship kindly see. Now, my lord, that is when they remained, my lord, that is silent on these issues. After, my lord, that is series of, now your lordship will kindly see, means 24/6/2022. These Forishchandra Bera, my lord, at page 36 of the supplementary affidavit, my lord. These are to be seen, my lord, because that if there is no micro-analysis of all these pages, my lord, that the who is in bona fide stand and who is on the mala fide stand cannot be. Therefore, my lord, it is such. Then, my lord, we took shelter of this honorable court thereafter. And, my lord, we proceeded at page 119 of my Can 1, my lord. Again, your lordship kindly take time at least to come to my
120 page.
My lord, page 119 of my Can, my lord. After all these representations, my lord, we proceeded. Because for long such and such, my lord, that the such period, my lord, I am not getting any advantage of my payment of such huge amount, my lord, for no fault on my part. My lord, your lordship kindly see at page 119 at P19.
The last portion of the order is not there. 120, it's incomplete.
No, my lord, page 120 is here.
That's incomplete.
My lord,
the order doesn't. This is the complete order.
My lord, at page 120, my lord, since no affidavit has been filed,
Generally, the name of the judges are there at the bottom. That marks the end of an order.
Yes, there must have to be. Your lordship has rightly
doesn't
pointed
appear
out.
to be.
Therefore, my lord, kindly, my lord.
If you have a complete copy, then later on supply.
My lord, we will.
If you have a complete copy, later on supply the last. You can find it from the.
We have also filed the writ petition, my lord, against those who filed.
No, this order.
Yes, yes. Annex, we annexed in the writ petition. Yes, yes.
Yeah. My lord, if the writ petition is before your lordship, my lord.
This writ petition, lordship, we are not made the party.
What writ petition?
This 119, this order. What they are pressing.
Why I am made party to it?
রিটে আছে না হলে পরে আমরা করতে হবে ওকে
Anyway, place it, Mr. Whatever. Main portion is there. So please. Place it, Mr. Adhikari, leave it.
136.
Oh, please place it, whatever is there.
Your lordship will kindly see page. My lord, very sorry, my lord.
139 of read
Yes,
petition.
please
My
place
lord.
whatever is there.
139.
139 of the read petition.
My lord, if the read petition be, my lord.
Difficult to go there, read whatever is there. Yes.
We file the read.
Read it, Mr. Adhikari, please. Don't waste time. Don't waste time.
And it is also, my lord, before your lordship. My lord, here, my lord, that we have stated, learned counsel for the petitioner submits that the copy of the read petition has been served such and such. The petitioner was granted mining lease by state respondents for a period of 5 years, commencing from 1st August 2017. The petitioner submits that he was unable to continue with mining operation for some time in 2019 due to personal difficulties. My lord, we were very, my lord, frank, my lord, we had not suppressed anything. We have, my lord, disclosed everything for some personal difficulties, because it is a personal difficulties. If I am, my lord, under pain, or my lord, I am such a critical
We
situation.
have seen the order.
My lord.
So
Yes, my lord,
the consideration was there.
before the-
Representation was directed to be considered, Mr. Adhikari. We have seen.
Next page.
So next what happened? We have read the order. Next.
Therefore, my lord.
Then the consideration is at page 121.
The read petition is disposed of directing the fourth respondent.
Seen.
My lord, your lord.
Page 121 is the fourth respondent's order. Let us see that.
My lord. Now, my lord, kindly have a look to the next page.
We have
Page
we are
120.
looking at the next to
My
next page.
My lord. It is the, my lord, it is the order dated 15/7/22, the order, and therefore, my lord, on, my lord, that on pressure from the, my lord, that the honorable court, my lord, whatever may be, my lord, the honorable court was, my lord, that there was the specific direction by this honorable court. That means that the while, by the deed court, my lord, that if whatever may be this institution, my lord, that the while, that you get it done, and my lord, that thereafter, my lord, on 25/7/22. Your lordship will kindly see in the next page, my lord, immediately next page.
We are looking at that.
Annexure J,
We
page
are looking
120.
there, yes.
My lord, in the top it is appearing, my lord, 27/22.
We have seen that. We are reading the order. We are in the midst of the order.
Your lordship will kindly see compliance proceeding against the order dated 15/7/22 passed by the Honorable High Court, Calcutta, in such and such versus. Whereas it appears that the Honorable High Court, Calcutta, has pleased to pass an order dated 15/7/22 in WPA number such and such in the matter of police and the Bera such and such, that is additional district magistrate and district land and reforms officer Jharkhand, to consider and dispose of the representation submitted by the petitioner dated 10th March 2022 within 25 July 2022 upon affording reasonable opportunity of hearing to the petitioner in accordance with law. In the event it is found that the petitioner, my lord, kindly this portion of the order, my lord, it has been recorded here, and my lord, that the I have not, my lord, that the stated there, I have not stated before your lordship there, but my lord, that the honorable court's order here it is. In the event it is found that the petitioner is entitled to the carrying order. Now, my lord, that the carrying order since the very beginning to end, even on 15/7/22, only my limited, my lord, that the prayer was carrying order. To the is entitled to the carrying order, the concerned authority should issue such carrying order in favor of the petitioner on the same date. Therefore, my lord, that the on the same date, when this was a serious, my lord, that the after considering all these things. Now, whereas it also appears that Harish Chandra Bera, the petitioner, in WPA number such and such, submitted a prayer dated 10/3/2022, wherein he stated the consequences in WPA number such and such arising from the registered partnership deed. My lord, there is wrong. Now he is importing registered partnership deed. My lord, Partnership Act is with me. What is registered partnership deed and what is unregistered partnership deed? Is, my lord, that the how this ADM has come to this conclusion that it is a registered partnership deed. Let them show. Your lordship kindly see whether it is at all a registered partnership or not. How serious non-application of mind, your lordship kindly see. Registered partnership, my lord, if it is such, my lord, register of property, my lord, whatever may be, register of all these, my lord, that the Societies Registration Act, it is such, and my lord, that is to be registered. Let them show. Let the state show. Because state, my lord, that the now state's representative is there, my lord, I will bow down before.
He says registered partnership deed.
What is, therefore, that if the registered partnership deed, it has been echoed there, it has got serious repercussions, my lord.
Why serious repercussions?
Because if it is not a registered one, then whether it can.
If the farm is registered, then it makes a difference.
Yes.
Anyway, let us continue.
No, my lord. No, my lord. There is a fine question, my lord. I will not, my lord, learn something from my learned friend and also from this court, my lord, that if it is written, that means it is a registered partnership firm, deed number such and such, executed by the petitioner and my lord, that then there is a serious repercussion because that it must have to be registered one. If it is not registered, it has got no value in the eye of the government because the government will encourage a registration. My lord, that if your lordship will kindly see it, that it is not Mr. Odhikari, it is not so important a matter.
My lord, Mr.
Then
Odhikari, my lord, stated something otherwise, my lord. In my paragraph 14 of the affidavit in opposition, I have stated the registered partnership deed being number ato registered and executed before the additional district sub-register. Sodor Paschim Mendipur.
Is it so?
This is a number is also given.
Yes, my lord.
But is
We have not stated that registered in the registration part.
No, can you
told it.
no, can you clarify it in this way?
Yes.
Therefore, are you not making involvement with the other side
No.
when the court has already opened it?
Serious involvement.
No, when the court has already made such type of means rather in
Serious involvement.
No, my lord, that I'm not. This is not a place of mockery, my lord. I'm always serious, my lord. I am to say, my lord, that if my lord, that
You
whether
have understood that this is not a place of mockery. So then please.
no. What I am,
please proceed.
my lord, what I am to say, my lord, that what he is saying, a damage controlling.
It's only you who is not understanding, Mr. Odhikari, that this is not a place of mockery. Please carry on.
No, my lord, with folded hand, I am saying, Mr.
Folded hand accepted registered partnership. Please proceed.
My lord,
Mr. Odhikari, we will not give you much time.
My lord, then my lord, I think, my lord, that my lord, that I think.
We will not extend the introduction.
No, my lord, the hosts of my lord, that because that today, when the resolution was taken, যে তার আত্মার শান্তির জন্য, and I was present and I was in this way also, তার আত্মার শান্তির জন্য.
Just see how you are wasting time, sir.
Therefore, no, my lord, I am not wasting time.
3 minutes we could have.
My lord, I think,
my
lord, what I am doing, my lord, your lordship can see. So, my lord, I am, my lord, that saying that this
Yes,
is
you are Mr. Bhuiya.
Partnership.
What is your name, please? Full name?
Mr. Purnasis Bhuiya.
Mr. Bhuiya, we will hold you responsible if he carries on further with this.
My lord, yes, my lord. What is my lord? That my lord, he is able at least to take because he is Bhuiya. My lord, your lordship can see. My lord. Your lordship, kindly see, my lord, I am vehemently opposing that it is not a registered partnership deed. And as a damage control, Mr. Day is saying that I have already stated that, well, it is a registered deed. But it is not. I will show the law, my lord.
Please, Mr. Day, just carry on.
My lord, I will show, my lord, that it is not possible because that the law, my lord, there are a series of laws, my lord, that is with me. That means that it is not negated. It is not allowed and it has been negated by the Supreme Court through a series of judgments that it is not such. Therefore, my lord, that it is the my lord that is serious flaw on their finding. Executed by the petitioner and 4 others pertaining to the sand mining lease deed in the sand block, era such and such in Muja such and such as was executed between the governor of West Bengal and the applicant. Whereas it also appears from the representation that the petitioner has prayed to take steps for issuing carrying order, which was stopped from August 2019, and extension of lease period for the cause of withholding carrying order and lockdown due to COVID-19 pandemic. In compliance with the solemn order of the Honorable High Court and to dispose of the representation as submitted by Horishchandra Bera, the petitioner in WPA such and such, a hearing is needed. The date of hearing is fixed on 25/7/22 at such and at the chamber of the underside. DA is directed to issue notice of all material interested parties. Now it is such. Now your lordship will kindly see 25/7, my lord, at page 122, my lord, at my lord, there is P212, my lord. Kindly.
We'll carry on next Thursday.
I'm grateful, my lord. I'm deeply obliged, my lord.
Although we substantially
my lord, that we are, my lord, that the outside it, my lord, that we are all, but my lord, that
let them supply the supplementary affidavit.
We are not supplying.
Give a copy of the.
Yes, just now.
Although the matter is substantially hurt, the part had mark করবেন না. Although the matter is substantially hurt, comma, the same cannot be concluded today due to paucity of time. List the matter next on April 9, 2026.
My lord, April 9, my lord, then my lord, that the entire mission will, because my lord, it is a sand mining, and my lord, the rain will come, and my lord, I will be there, my lord. But no, my lord, next Thursday, my lord, I will take very short period, my lord. Next Thursday.
This is the last.
April 9 is the next Thursday.
Next Thursday to April. My lord,
we are in April 2nd, on April 2nd.
Next 5 days to
Next,
no
ঠিক
তারিখ,
আছে,
আজকে
ঠিক
কত
আছে।
তারিখ?
9th on 9th. I'm grateful, my lord, because I always remain apprehended with my leader. I am actually between two fires, my lord. Actually,
You are actually
between two fires.
which fire?
This time, my lord, this side and this side. And your lordship is the most powerful, at least, that to save ours. I'm grateful, my lord. Next Thursday, yeah?